Sir, ಇದು portal 1 ಇಂದ any mention through VC ಸರ್ ಎಲ್ಲ ಫಿಸಿಕಲ್ ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡಿ ಸರ್. ಥ್ರೂ VC ಅಲ್ಲಿ ಯಾರು ಮೆನ್ಷನ್ ಮಾಡೋವಾಗಿದ್ರೆ please mention it after the mention of the advocates who are physically present before the court today. Thank you.
Yes. On contempt memo, your lordship. The single judge has passed an order.
Then why don't you wait after removal of office object? List, wait, it will be listed after you remove the office object. It's going to be, it is listed within 1 week. If we give date, we will give in December or November last week, whatever you want. Wait.
Its office objections is complied. Kindly have it at the end of the list in the afternoon.
Not after. Tomorrow.
Memo for posting public interest litigation, my lord.
A memo for office objections have been complied, my lords. This petition is filed for violation of mining lease, my lords. Deemed extension has not been granted, although other applicants, the extension has been granted, my lord.
Wait for some time if it is complied with. Then mention in the next week if it is not listed.
My lords, so office objections have been complied and
Once they are complied with, they will be listed within 1 week. In fact, within 5 days, but I am saying within 1 week.
my lords, actually 2 weeks extension was granted for compliance of office objections. We have complied it and more than 3 weeks has been passed, my lords, and date. More than 3 weeks has been passed. The matter has not been listed, my lords. So kindly have it this.
6th of November.
Lord, memo for posting a pending public interest litigation, my lord. In a residential area in Tumkur district, my lord, in adjacent Tumkur district, residents are not able to breathe, my lord. They're finding difficult to breathe due to rearing of pig that is happening in a public park, my lord. This was listed twice, my lord. It did not reach, my lord. Extreme emergencies, they're not. They're finding difficult to breathe, my lord.
File IA.
Lord?
In a pending matter, by memo will not post unless IA is filed. Yes.
I will file, my lord.
Commercial appeal, my lord.
Parties have settled their dispute only for reporting settlement. Request for tomorrow.
Tomorrow. Settled
For reporting, matter has been settled.
tomorrow.
Great.
It can be Monday.
Please,
Monday.
My lord, office objections have been complied, my lord. 2 weeks time was granted. It's been 3 weeks, my lord. Even then, it's not been listed.
We list
Matter relates to writ petition. Writ petition, my lords.
relates to.
Writ petition, my lords. Writ of mandamus.
That is too general an argument. Wait for 1 week.
My lords, it's been 3 weeks, my lords.
What is the urgency?
It's a land which is being demolished by R7. It's an
It will
200
be-
years old land, my lord.
It will be listed by the, it will be listed by the registry.
Any date, my lords.
Any date in 3rd December. Yes.
Identical matter, Lord, arising out of the same order. Is listed to that court title 1037. Lordship may kindly order to take this matter along with it.
It can't be like that.
Lord, same order. Lord.
At the time it is called out, you request.
Matter involves urgency because the election is notified.
Maybe.
28 is the scrutiny.
Whatever it may be, it can't be listed in this place. When it is, the other matter is taken up, you mention it. We have said no. Yes,
Lord, commercial appeal,
yes.
execution, my lord, is filed already. It is listed on 8/11. Some urgency, my lord, insofar as this commercial appeals are concerned. There are about 12 commercial appeals filed before your lordships. My lord, BBMP is before your lordships. Lord, short question, my lord, is this. Despite, my lord, me paying the amounts, that amount is not taken into consideration by the learned arbitrator. When I bring it to the notice of the 34 court also does not exercise its jurisdiction. Now, my lord, I have been saddled with huge amounts. This amount is already paid by me.
It is appeal under section 37.
37, yes, ma'am.
So what do you want? 6th,
Yes, please,
6th,
please.
6th.
My lord, in contempt matter, I am for the accused matter. I have complied and compliance affidavit also filed, madam. Other side, I assured that once it is listed, he will withdraw the petition. Compliance.
Monday?
My lord.
Monday.
Lords, serial number 94 on the list today, my lords. There's some urgency in the matter subject to the convenience of my lordship if it could be taken up at 2:30.
What is the urgency?
My lords, the urgency is that this is arising out of an impugned order of the learned single judge wherein we had challenged the validity of the assignment agreement in favor of an ARC. Now, on the basis of that assignment, they had filed a section 7 application which came to be admitted before the insolvency and bankruptcy court. Now, that is an appeal before the NCLAT and the final hearing is going on. Therefore, the validity of the assignment agreement is being adjudged before my lords. And it is on that basis they had filed the NCL.
5th November.
5th November.
My lord's pending public interest litigation matter. This matter has not been listed for nearly 2 years, my lord. The Honorable Court in its order has directed for the inspection of the elephant in its custody, in the custody of the respondent number 4. However, the Forest Department is unable to locate the elephant, my lord. So can you request for a day this week, my lord?
You have to file IA.
Sorry, my lord?
File IA. Not now, not by this member. File an IA and then request for listing of IA.
My lord, other connected writ appeals are listed on 29/10, my lord. There is a fresh matter and I compared all the office objections. I request this matter to be.
That you tell the office that the similar matter are listed on particular date. Office will list.
That is in the pending, my lord. There is a fresh matter, my lord, that is already.
So you tell the office that the similar matters are listed on such a such date. So office will list on that day. Right? Yes, please.
Your Honor?
Serial number 28 has, that means I request for a week's time.
28. At the request of your petitioner, appellant, at the request of learned advocate for the appellant, Mr. Swansea. Send over to 28. It is a commercial appeal. To give for reading. Which date? 7th?
Any date can.
7th now.
Serial number 13, my lords. I appear for the appellant in this matter. Senior has some personal inconvenience today and is
Serial number 2.
Serial number 13, my lord. I appear for the appellant.
13.
Yes, my lord.
I appear for the respond number 2, my lord. I oppose this adjournment. They've been taking.
My lord, they've already informed the.
You've informed us, we have not agreed to the adjournment.
My lords, a date may be fixed, my lords. He has some personal inconvenience
But,
undertaking travel. My lords.
The council is right, it is 22 matter. Why you are second?
My lords, any short date may be fixed, my lords. We will.
It is under which law?
My lord, what has happened is there is a order against them where the institute has to designate the respondent number 2 to a higher designation and also release her retirement benefits. They have withheld the retirement benefits and we filed a contempt also. And now she's finding it difficult to live month to month, my lord.
7.
Please, my lords.
Obliged.
Lord, serial number. Lord, serial number 87.
Your Honor, serial number 81. It's posted for orders today. For receiving the interim relief orders, should I be present in the Honorable Court?
Okay. Office objection. So some office objection to be removed by you.
Your Honor.
Some office objection is to be removed by you.
The memo I filed is exactly the same with no changes to the prayer, except for, a just correction in the sentence stating that according to the recognition of Honorable Court, the breach of patent cooperation treaty and orders issued by the Honorable Court annexure be attached for WP 12356 of 2023 on 14/6/2024. The interim relief be granted. That is the only amendment, and hence, upon your instructions, I did not file an IA, but it is a memo that was filed. There's absolutely the entire prayer is exactly the same. So the prayer at the time of when it is filed is exactly the same. Your Honor.
Let us see what happens when it reaches.
Your Honor, I request that the interim relief be granted, and if the respondent has any.
Let it be heard, it is a still number 81, then we'll consider on merits.
Suggest I wait for the number to be.
For you to decide. We cannot
Generally,
say whether you
Your
wait
Honor,
or go outside or sit in the chair or, that is not for our suggestion.
No, that is, in my earlier experiences, generally 81 has not been called in the first half or second half. So
Either you
that's the
learn-
reason I'm requesting that if.
Whether you learn from the court or learn from your matter or learn from experience, 3 options are available.
I'll wait for it to be called.
Whatever, yes.
Lord, serial number 87.
87.
Raised for 1 week of adjournment. My lord. Adjournment for 1 week. 87.
It is 3 weeks time is granted to comply with the office objects.
My lord.
3 weeks time is granted to comply with the office objects. Right? It is for removal of office objections.
Yes, my lord.
Do it within 3 weeks. Right?
Pleasure.
Serial number 50, Your Lordship. Serial number 50.
50.
I would request for a week's time, Your Lordship.
What?
Objections are.
Right.
Objections are ready.
It is PIL relating to.
Regarding to a mosque in Mysore, Srirangpatna.
My lord, running of a madrasa in a
Madrasa.
mosque, my lord.
Objections are ready, Your Lordship. CO signature is required.
You want to run madrasa or don't want to run?
Objections are ready. Your
No, you tell us. We will grant time. You want to run the madrasa or don't want to run?
We want to.
Want to run. Got it. So when shall we keep? 12th November. At the request of learned advocate for the petitioner, stand over to 12th November. 50. Serial number 50.
My lord.
Yes, madam, you want to mention?
Madam, mention
My lord,
Yeah.
my lord, serial number 83. I seek for an adjournment, my lords. This file has been for appellant. This file has been assigned by legal services. Now, client
83.
has intimated the legal services to
83 3rd December. as requested, stand out to third
Obliged.
December as requested by the appellant.
Content matters, seal number 1.
My lords, I appear for the complainant in this
JJ.
matter, my lords. We are giving NOC to the client, my lords, so a date may be given for them to appear and for a fresh counsel to file their wakalat, my lords.
You have to respond.
Appear for the complainant, my lords. NOC has been given in this matter, my lords, a date.
Further counsel.
My lords?
NOC is given to another.
My lords, if we are giving it to the client, my lords, they have to engage in other counsel, so a date may be given for them to engage a counsel, my lords.
Advocate Ms. So-and-so, so request that since she will be replaced by another learned advocate, time may be given, stand out. Which date? Which date, madam?
My lords, any date, my lords, convenience of this court, my lords.
20th November as requested.
Seal number 2. To Markandeya.
Compliance is.
For the complainant,
That's is filed, filed by.
I have not received the complaints report, my lordship, because the notice is not yet ordered, my lordship. Before ordering the notice, my lordship, the respondents have filed.
That is very good, they are fast.
This is shows, my lordship, as to how the respondents are following us. This itself is very clearly shows that respondent as to how they are following us, my lordship, because this is the property belongs to the temple, my lordship. As per the order of this honorable court, my lordship, void annexure D. This honorable court has directed the respondents to mutate the name of the temple in the relevant revenue records. In page, my lordship, page 23, annexure D is the order of this honorable court, my lordship. After obtaining the certified copy of this order, my lordship, I have made a representation on 21st December 2021 to the accused. Subsequently, my lordship, by considering the order of this honorable court void annexure F, the respondents have mutated page 31, my lordship. The name of the temple in the relevant revenue records at mutation register as well as the RTC is also the name of the temple has been shown. Subsequently, my lordship, when the mutation is registered in the name of the temple, without issuing notice, my lordship, on 12 October 2022, again they have cancelled the mutation registered mutated in the name of the temple as per annexure H, my lordship. Page 35, my lordship.
To compliance affidavit.
I have not seen, Lord.
Paragraph 3 and 4.
It maybe have it on day after tomorrow, my lordship, I will get back with the. It maybe have it on day after tomorrow, my lordship.
There is nothing in the matter now. The representatives have decided in your favor on 19/8/24. Thereafter, this Siddharth Education Society went before the Assistant Charity Commissioner, and got its name mutated.
My lordship, the order of this honorable court is very specific, my lordship, page, my lordship, with annexure D.
The order is specific, the compliance is specific.
My lordship, my humble request, my lordship, I draw your kind attention, page 26 of the order, page 26 of the order, my lordship, wherein this honorable court has specifically directed, page 26. If the respondent is of the opinion that there exists a dispute regarding the entry of the name of the petitioner as well as the Siddhartha Education Society in respect of the land in question, the respondent is bound in law to register it as a disputed case and initiate an inquiry under section 129 of the Karnataka Land Revenue Act 1964 so as to enter the name of the person who is lawfully entitled to the property in question. So this exercise was not done. On the other hand, my lordship, wherein after initiation of inquiry, my lordship, they ought to have issued notice to the either of the parties, my lordship, but without issuing the notice, my lordship, the entry has been cancelled. This is nothing but aggravated contempt, my lordship.
Lord learned advocate Mr. So-and-so, so-and-so for the complainant. And learned additional government advocate Ms. Pramodini Kishan, who has filed, who has appeared upon service of copy of the petition in advance. While disposing of writ petition number equal to 13 of 2021 on 6th December 2021, on a single judge passed following directions. Page 26 operative. Array, bracketed portion. After quoting court the bracketed portion, the directions were required to be complied with within 6 months. First of when the complainant, when the contempt petition alleging non-compliance was filed and came up today for consideration from a learned additional government advocate, submitted that the order, that the direction in the order are already complied with. Paragraph. He invited attention of the court to the compliance affidavit filed by the Tahsildar, Tumkur Taluka, Tumkur District. Dated 23rd August 2024. He stated, paragraph, in the affidavit on oath that after the order of learned single judge, documents were verified and the representation of the complainant was considered. Endorsement dated 19/8/24 was issued. Post of it was stated that the revenue entries in RTC were entered in the name of the complainant after considering representation pursuant to the orders of the court. Paragraph. Not paragraph. The endorsement dated 19/8/24 deciding the representation as above is produced on record. Paragraph. In view of above, comma, the directions are complied with and no allegation of contempt survives. Full stop. Not only that, it is further stated, it may be stated that the deponent has highlighted the further development in the affidavit, in the compliance affidavit, stating inter-alia that when Siddharth Education Society filed appeal before the Assistant Commissioner in respect of the RTC entered into in the name of the complainant as above, and that the Assistant Commissioner has passed order dated 9/9/22 to enter the revenue entries in the name of the said Siddharth Education Society. Be as it may, paragraph, nothing survives in the present contempt proceedings. They are not surviving.
Number 3, the submit is
Appearing for the complainant's manner.
Notice returnable on 20th November.
Acknowledgement.
Live. What is the direction?
To conduct the podium durust work.
Podium.
Podium durust work within a matter of 2 months.
Sorry.
Representation was made in the month of May. And the petition was filed in the month, the complaint was filed in the month of August. This contempt petition was filed in the month of August. It's been close to 4 months that they haven't conducted the durust and podi work.
They are issuing notice.
Acknowledge.
number 4. So Chokka Reddy,
For complainant matter. 3 months directions issued by the Tahsildar to the Tahsildar matter. The arrears of land revenue. There is a page number 14 in the.
Is returnable on 19th November.
Yes, please.
number 5,
Arrears of rent
Harish
amount
HV.
are not paid in spite of the direction and settlement in the regular appeal court lordships. And from 2011, they are not paid, and there is even execution petition filed by me came to be withdrawn on that undertaking given before the court lordships. Page 12.
This compromise is translated into decree.
Lordships, sorry,
The compromise was entered into before the city civil court.
before the regular first appeal before the Honorable High Court lordships.
Notice returnable on 20th December,
Please,
20th November.
Yes.
the PL matters. Still number 6, to Keshav M. Datar.
There's a mandamus direction seeking them to construct a road and give proper lighting, my lords. Your lordships could take page number 87. This is one of the.
By filing this, heard learned advocate, and learned edit. You want to construct tar road.
My lords, please, my lords, because of the present condition.
The representatives directing to provide an tar road, HR road for the benefit of students, villages, and hospital. So what is paragraph 7?
My lords. It is adjacent to the property, my
Yes,
lords.
sir.
The forest land is.
Sir, you are a trust.
I am a trust.
So you have constructed or set up a management and arts institution.
Please, my lords.
So the road is using your road, you need road for your purpose also.
It's also for my purpose. I also have, and I've also stated that, my lords.
The prayer in the petition is for directing the respondents to construct a tar road. Full stop. It was admitted in course of the submission by learned advocate Mr. So and so, so and so. It also transpires from the adjournments made in paragraph 6 and 7 that the petition trust has constructed, has set up a management and art institution within the village at the place where the construction of the road is spread. In other words, the present petition styled as public interest petition is fairly guided by the private.
My lord, if I may be permitted to place two judgments on record.
Interest. So petitioner who indirectly wants to grind his own interest of having a road.
Permit me to kindly place a judgment on record, my lord.
Full stop. The thoroughly misconceived petition is dismissed with cost of rupees 5,000 to be paid within 15 days to the Karnataka High Court Legal Aid Services Committee.
My lord, permit me to kindly place judgments on record, my lords, that say that even though I have some personal interest, I can still maintain a public interest litigation.
Then the order will be altered and we will not permit you to. Learned advocate, even after passing of the order, learned advocate wanted to argue the matter and submit the The insistive approach is deprecated, however, court considered. What is this?
My lord, this is a judgment passed by the Supreme Court, my lord, para 23. Para 23, my lords.
Your audacity is appreciable. Yes, 23. Your audacity before the first court is appreciable, Mr. Counsel. You are too young to be advised. Yes, proceed and tell.
My apologies, my lords. My apologies.
Yes, proceed. Which even after passing the order, you are going to argue.
My lords, my
You are
apologies.
too young to learn the things.
My apologies, man.
Yes, which paragraph? We are going to hear you now.
My apologies, man.
We are going to hear you now, Mr. Counsel. Yes.
No, it's para 23, man.
Read it.
However, a genuine case brought before a court by a public interest litigation may be the court has declined its examination at the behest of a person who in fact is not a public interest litigant and whose bona fides and credentials are in doubt. In a given exceptional case where bona fides of a public interest litigation are in doubt, the court may still continue to issue having regard to the serious nature of the case.
In course of the submission, learned advocate for the petitioner relied on the decision of the Supreme Court in T.N. Odavaram, Thiru, Mulford versus Union of India 2006 5 SCC 5 SCC 28, more particularly the observations made in paragraph 23 thereof. In which it is observed that only a person acting bona fide can approach the court in public interest, and that such a remedy is not open to an unscrupulous person who acts for someone else. Though in exceptional cases, it was stated that the court may still examine the issue having regard to the serious nature of the public cause and likely public injury by appointing amicus curiae. The court would under no circumstance do with such assistance of a doubtful public interest litigation. Full stop. In the facts of the case, when the petitioner has a direct interest, his bona fide are to be indeed doubted as public interest petitioner. The locus standi as public interest litigant is totally lacking.
Seal number 7, Mr. Shiv Kumar N.
A matter regarding franking of stamp papers with the same numbers and
regarding
this honorable.
My lord, I received instructions, my lord, based on what my lord had directed. My lord, based on my letter, my lord, the finance department has asked the state accounts department to conduct a special audit of these two sub-registrar's office in Mysore. My lord, they will submit a report. Based on that report, my lord, we'll take some action. My lord may grant me 2 weeks' time. I'll keep my lord abreast of what decision we are taking.
Put these things on affidavit.
Yes, I will do that.
That the
Yes.
report is, the auditing is direct.
Yes, fair.
Learned counsel, learned additional government advocate, Ms. Nilofer Akbar. Submitted, when the petition came up for consideration, inter-alia that in light of clear order dated 21/9/24 passed by the court, the necessary steps are taken by the competent authorities and the audit of the department concerned.
State government. State government audit.
State government audit of the department concerned is direct, full stop. Such facts may be put on affidavit.
Yes, ma'am.
Within 2 weeks, stand
Obliged.
over to 19th November.
Obliged.
Seal number 8.
But I beg to appear for petitioners. Lord, this is a burning issue in Bangalore, as we see, lots have also seen.
My lords, I appear for BBMP. I was
And
required to file an affidavit. I seek for a week's accommodation, my lords. All the engineers are now busy clearing the water which is on
Then
the.
this is a road school.
This is the
about the
quality of roads,
potholes
my
in
lord.
the city. But every bench has noted that this is a serious issue and requires attention, but somehow BBMP always has a great knack of dodging.
Not at all, my lords. I am asking for a week's accommodation. Affidavit will be filed in this regard.
What do you do after we grant time?
I'll file the affidavit, my lords. The last order says that I have to file an affidavit on the work that has to be undertaken whenever there is any potholes on the roads.
Not filed so far.
My lords, I have week's accommodation. I'll file it.
Honored Advocate Mr. Sons for VBMP. Praise for time to file necessary affidavit as directed in earlier order dated 21/9/24. Time is granted. Affidavit required to be filed shall be filed within before next date of posting of the petition, 10 or to 21st November.
Great, Minister.
22nd, if I may persuade my lords, 22nd is
22nd.
obliged.
Number 9. To K.S. Raghuram.
The respondent. But this petition is
I'm for
filed
the-
seeking for demolition of a temple. Supreme Court has passed an order saying that from 29/9/2009 onwards, no unauthorized construction should take place. Prior to that, wherever construction has come up, it has to be, a decision has to be taken on a case-to-case basis. Now, it is our case, this is our construction of a temple is prior to 2009. I have no objection, my lord, let the corporation look into the matter, take a decision in the matter according to Supreme Court judgment.
Who will take this?
That is the
BBMP
respondent,
has-
BBMP has to take a decision.
PMY should take.
BBMP, my lord.
BBMP, my lord, is a,
What decision, whether it is constructed before
On the footpath or not?
on the footpath or?
no, what they say is whether it is unauthorized or, blood, kindly take the written submission filed by the state government. They have produced the Supreme Court order. Written submission filed by the government. Okay. At page 11, my lord, is the order dated 29/9/2009.
Which is the one senior reading this one?
Relevant portion is at page 14, operative portion.
We don't have that. Indeed, there is no.
What was the original prayer?
What?
What was the original prayer?
The demolition prayer is to demolish the temple, seeking for a mandamus. Remove the structure, unauthorized structure. Mandamus directing BBMP to demolish the unauthorized temple constructed on the footpath of the main road. According to us, my lord, the road was widened subsequently after the formation of the temple.
Where is the report?
What?
Report was.
A report of the BBMP is yet to take a decision, my lord. There is a BBMP has filed statement of objection. At page 25 of their statement of objection. They say that the statue is about 60 to 70 years old. Objection. Their objection. The government. ಅಲ್ಲ ಅಲ್ಲ ಅವರು ಹೇಳ್ತಾರಲ್ಲ 2008 ಅಂತ ಇದಾ
There was some report. Where is?
There is a report, my lord, which the objection filed by the corporation. I think we have produced it, their report, but who ಹಾಕಿದ್ದಾರೆ? Huh? I think BBMP has not filed.
Report suggesting that it is an old temple.
Yes.
Actually, I'm appearing for BBMP. We have filed an affidavit at that time where we have stated that it's a temple which has been constructed before 7/12/2009.
Where is that? That is what we want.
It was filed. It was filed in the open court, my lordship, in 11/12/2019. In the year 2019, 11/12/2019.
11/12/2009.
Right.
19th category report. Eleven, 12, 19. So this is after the order of Supreme Court?
Before, my lordship.
Before.
Before. Direction was given by.
Construction is before,
No,
inspection.
no, this affidavit.
Affidavit is before, my lordship, before the order.
Then what was the occasion for the anybody, either of the party to go to Supreme Court?
Because we were not impleaded, we went to Supreme Court.
You were not in.
I was not impleaded, so I went to Supreme Court,
When the Supreme Court passed the order, this stand of the BBMC was already there on record.
already there.
Yes, it was.
That Supreme Court order also.
Supreme Court order is dated.
A Supreme Court order, my lord, that written submissions, that is dated 11/8/2020.
Acha, so it is prior to.
Really. There, my lord, in the order of the Supreme Court is produced along with the written submission of the state government. There also there it is constructed old temple.
Yes. Sanatana Kalakshetra, what is this letter?
It's a trust, Your Honor. It's a trust. We do the promotion of dance and art.
What is this letter at page 43?
Huh?
Along with your affidavit. In 98 and 88.
The complaint, my lordship, at that time it was
Signed
by
crops of
BBMP
a 12-plan layout.
to show that the temple was in existence in the year 98 also. These documents were produced. Which it's a complaint received by the BBMP at that time, my lordship.
Complaint issued by
Received by BBMP at that
regarding this alleged encroachment.
Yes, my lords. It was produced to show that that temple was in existence at that time also.
No, not this report. There was somewhere it is stated that this temple is very old. Where is that report? We had seen in course of. This is about the.
Supreme Court also, Lord, has noted that observation. No, that is the submission of the devotees that it's 1854, formed in 1854.
Correct.
The Jainagar layout is the one of the best planned layout, Your Honor. The best planned layout entire in Asia. I have produced the document of the layout sketch produced by BDA in a document number 4A in page number 21 along with my rejoinder, where my property is very clearly shown in front of it.
You know that
There is a road. There is no temple as such.
There is a saying in English. Just you stay in the Jainagar.
Yes, Your Honor.
So those stay in which house? Don't throw the. Yes. So this is, we are not saying anything. We'll just be examining. We just noticed it therefore, that you are also staying at Jayanagar. Yes. Please. Temple is empty and land. This is Devasthana. Devasthana.
They call it as a temple. Yes, sir.
They
Temple.
call it Devasthana. So.
Yes.
Devasthana.
Jain temple. In Gujarat, the Devasthana means Jain temple.
Oh.
Jain people call their temple to be Devasthana.
Oh. In Kannada, Lord, in Kannada temple equivalent word is Devasthana.
Temple means Devasthana, that is right. Both are synonyms. Yes, sir.
In Gujarati, temple is referred as what, Lord? In Gujarati, temple is called as what, by what name?
Mandir.
Oh, Mandir. No, here also they call Mandir, Devasthana and Mandir both.
This is report of the text. And if, yes, what do you want to say?
Your Honor, this is the temple.
You are running some Kalakshetra.
Yes, Your Honor.
But kindly see the order of the Supreme Court, my lord, which is at page 5 of the written submission, where they make a note of this affidavit filed by the Assistant Executive Engineer. The temple is constructed well before 7/2/2000. 2009.
No, statement is.
Madam, another copy.
I'll take a Xerox and give you.
All right.
I just Xerox it.
Still number 10.
May I please? Lord, in WP number, which is the third serial number, Lord, 2406 of 2024, Lord. May I request for 2 weeks' time, Lord, to file objections now. There is a detailed standard operating procedure which has been laid down for capture of Asian elephants, Lord. There was also an international conference. File it along with my objections also, Lord. Where every step is meticulously planned. Recent, the international conference was in the month of August. 12th August, and I also personally visited the Hassan division, Lord, to see the control room. The control room, my lord, displaces location of about 65 to 70 elephants. Their location is constantly disclosed by the 140 personnels who in fact sleep in the field itself, my lord, to track their location. And these 65 to 70 elephants, my lord, at any given point of time are outside the forest and are situated and are virtually resident of in the coffee estate itself. But their location is transmitted by SMS, and the control room itself displaces the location of the elephants, so that rapid response team can reach. So all these facts, Lord, I will bring it out in the objections. May I request for 2 weeks' time, Lord? Yes. May I make one submission? Absolutely no objection so far as the time is concerned. Now, only request is, my lord could kindly see para 7 of their, page 7 of their statement of objections. Page 7. It was. They just pass on my copy, mate. Yes, second paragraph, means solar fences. Over the last decade, 2013-14 to 20, around 3,426 kilometers of solar fences have been installed. These fences meet the national soil law. Now, this runs counter to the central government circular dated 11/11/2009, which I invited my lord's attention, my lord, referred to in the judgment of the Madras High Court, my lord. I had given a copy of the judgment. Just, madam. And the Kartursi. It was given on the last occasion. Very some case. They may clarify their stand in there. The middle paragraph, by the order, other letter dated so and so, issued by the Government of India from its Ministry of Environment, a specific direction has been given to ensure that no solar power fencing is erected in future. Whereas in page 7 of the statement of objections, they say that we had taken instructions to action to put up solar fencing. So how they overcome this government order may be clarified by my learned friend Miller in the objections. They would like to. Yes, but that's what in solar, the same as solar fencing, page 7.
This says
Page 7.
unregulated voltage.
Yes,
Ours is pulsating solar fences.
Page 7, they say, have been installed. There, para 2, page 7. Over the last decade, 2013-14 to 2023-24, that is subsequent to the letter of government circular, around 3,426 kilometers of solar fences have been installed. That's subsequent to the circular. How they've overcome, let them clarify so that it will be easy for argument's sake thereafter. That's the only request I make.
We'll respond to it.
Two minutes. Government of India. That paragraph 15 is very clear on the previous page of this judgment. It has been brought to the notice of the court that Government of India from its Ministry of Environment has issued 2 directions with regard to elephant corridors addressed to the chief of all the states and the union territories. So they can't say they are not ignorant of this. And how they overcome, let them clarify. And that circular is extracted in the first part of page 7 minutes.
It reads, the ministry is receiving reports of deaths in tea coffee estates, especially in Assam and Karnataka. Page 7, due to unregulated voltage in solar power fencing erected by them. We have given pictures of our solar fencing. It's a pulsating solar fencing, which has been erected. It's not unregulated voltage solar, and this refers.
No solar, that's what it is.
I'll look into it and will respond to it. May I request? See the date.
Number 11. Let's go. Started with 15, 15, 6. I think this next page. Up to 21. 15 to 20.
Where does it say no? Check. Doesn't think. Plus.
ಇದೊಂದು ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ.
I request.
This section.
Yes.
My lord, Lord, the similar issue had come up before this honorable court in, my lord, 14029 of 2008, my lord. 14029 of 2008. I've just handed over the number to the court officer.
That's a
My
judgment
lord,
I
in
had
this-
given, Minister.
In the, in
It's
this,
the
my
reported
lord,
judgment.
It's a reported judgment, my
Reported
lord, and in
judgment.
this
I already given.
judgment, certain directions have been given to Union of India along with the state, my lord. That would be easy to dispose of.
It's the reported judgment I have already given copy, Minister.
Lord, may I request for 3 weeks' time? Gratefully.
Sir, there are two judgments, two judgments. ಹೌದು. Great.
22nd.
Bench matters. Bill number 11. Mr. Manjunath.
Identical dispose of the sample koturan. Madam. Madam. Annappa for Manjunath G. Kandekar. Annappa for Manjunath G. Kandekar. ANNA. ANNA PPA.
This is the case where not seeking writ of mandamus, seeking writ of mandamus not the requesting the authorities to consider the AQL application filed in the year 2015, which has not been considered and disposed of till date, despite there being a direction from this honorable court in previous occasion. And now, not that there is an amendment in the year 2023, under which not a time limit is prescribed for a period of 24 months from its not coming into force. Now 24 months not coming to end in the month of March 2025. Not petitioner has already complied with all statutory compliances which are required. NOCs are issued, technical report issued, and also GL notification is published as per Annexure F. But with all this, authorities, respond number 3, who is competent authority is not taking decision before and before this. Annexure F is the notification which was issued in the year 2018, page number 48 note. GL notification, under which approval has been given to execute the quarrying lease. Short date. Much. 13 urgents, seal number 14, writ appeal matters to Madhusudan G. 14.
There has been a delay of 52 days in filing the appeal. The petitioners are all aged people and they're also represented by one power of attorney holder. He was also unwell and then he could not give instructions. And therefore, there has been a delay, my lord. Yes, there is one. Yes.
My lord, sought for deletion, respond number 5, my lord. Deletion. Notice has to go for respond number. Yes. Number 15,
Sanjeev PL.
Thank you.
Second one is. Lord, this matter had been heard, my lord, for some time. I had made only one submission, my lord. I had, my lord, practically submitted that our officers had not produced all the documentation that was needed, my lord, to justify that there are three categories of workmen, my lord, that we employ for cleaning. One is on a permanent basis, another one was on contract basis, and the third is temporary. They are, my lord, like engaged from time to time. The main controversy, my lord, the Provident Fund Department raised was asking for details of the contributions made for these categories of persons. Now, my lord, they gave us the notice, my lord. We submitted. The difficulty for us was that these contract employees are engaged through a contractor, and that is a tendered process. We issue publication notice, persons make a bid, and we give them the contract. In the contract, there's a clause that all labor payments and laws have to be complied by the contractor. So according to, and we have to, my lord, they have to produce information to us to show that they have complied. So when they give it to us, we may not satisfy ourselves that it has been duly complied, then we pay the contractor. That's the procedure that has been followed. Now, my lord, the department raises certain questions, but in those proceedings, the contractors were not parties. So, my lord, what happened was whatever information we had, we have furnished. But the department, that is the Provident Fund Authority, my lord, goes into the question and says that with reference to each individual, I don't have information. There are so many thousand people employed. And since we don't have the information, they proceed on the basis that they were not covered. So, my lord, I made a request on the last date, my lord. After all, my lord, I am a public authority. I'm not some private person who will run away anywhere. And now, my lord, the development is all this third category of purely casual, they've all come on our rolls. So today there is no difficulty. They're all on our rolls. We are paying them salary and we are complying with all the regulations. The period for which, my lord, this problem arises now is 2011 to 2017. That is the period for which this inquiry was held, and a demand of 90 crores has been made, which we have already paid, my lord, subject. January 2011.
January.
Yes. To July 2017. This is the period now, my lord, which is for which this demand of 90.18 crores has been made. So my only humble request, my lord, is after all, if this money has to be paid, it is going to come from the taxpayer only. Yeah, and I am, my lord, a municipal authority. Therefore, my lord, I am pleading, my lord, some consideration may be given to me so that I will go back to the authority, my lord, and furnish. Now, my lord, in the course of these proceedings,
That can be done. Yes.
this money is already with them, my lord. I'm only making one more request for that, my lord. This money is actually to go to the workmen. Ultimately, my lord, the PF authority is only agency, my lord, which ensures that it goes. They are all now my employees. They have each an individual number, everything is available to them. Not to tide over my financial crisis, my lord, if your lordships could consider directing that money to be paid to me, I'll give a bank guarantee. I'm authority, my lord. I'm a public body. I'll give, because this money is not for the PF authority to keep and enjoy. I can understand in a commercial dispute what happens. A person who has received the money,
Who are they?
they are PF authority, Commissioner for Provident Fund.
Commissioner.
So this money, they have not yet credited, my lord, or used this money. It is because of the order I have complied.
Will it not amount to going too far?
I leave it to your lordships, my lord. Only reason I'm making this submission is appearing for this authority. The whole object is if ultimately this demand is reconfirmed, I should be able to make the payment.
Within 10 weeks, this exercise can be over.
Please,
You can go before them,
grateful.
produce your documents
Please,
and put up your case.
please,
May make submission.
Till then, nothing will
very well.
proceed.
Please.
Like
No, the
before-
money is already with them, so there's nothing more that I need to.
After the decision, what?
Depending on what order they would make, then that authority can decide, my lord, on this money also. If it is held that I'm not liable, it will come back to me.
So with such a mechanism provided
May-
finally, this can be disposed of finally.
My lord, may make submission before.
They have to decide it.
This can be disposed of finally with such.
Yes,
delay.
my lord, that's my respectful submission.
May make submissions. My lord, so far as this 8F is concerned, my lord, they have produced the documents concerned to the employees. It is not that without documents produced by them, we have passed orders. I have produced the same before this honorable.
But you
court.
may also appear before the authority.
My lord, I have already produced whatever they have produced. Based on that only we have
My
assessed.
learned friend is appearing for the PF authority.
I appear for the.
He is appearing for the Provident Fund Commissioner. I'm only requesting them to relook at it, my lord, with all the material that is available. My lord.
That is
Because I
impracticable.
plead that I didn't give all the information. Lord. I'm not mincing words there.
May make submission. My lord, their contention is that the inquiry, even though conducted, the amount which has been arrived by the authority is not, it is incorrect, not based logically on the employer's list. My lord, your lordship may kindly, now they have filed an interlocutory application taking that we have to produce the documents, the basis for which the order came to be passed. Now I have produced, those documents were produced by them only, nothing survives for them. Even if they go back also, because what they want to ultimately is 1 year time period is there, that limitation has already expired. Because of the reason that they have come before the court of late, and these contentions were also urged before the learned single judge. Your lordship may kindly take that application which they have filed seeking for documents, furnishing of documents by the authorities, and I have produced. And those documents were produced by them only. Based on those documents, you have passed order. How a wrong could be attested? On 12/8/2024, I have filed me for the IA which they have sought for documents.
There's no intention, my lord, to avoid any payment. I'm only requesting, my lord, them to relook at it. That's all that I'm saying, my lord. The reason is this, that in the
Mr. Nagananda, it appears that you are only on quantum.
Only on quantum. All that I'm submitting, my lord, is this, that if your lordship see in the objection, they've said
The
that
reason you know, we need not tell.
yes,
Why
my
you are
lord.
only on quantum.
Yes, my lord. What I'm
You can't travel beyond that.
yes, what they are saying, my lord, is that there are certain Paura Karmikas who have not been paid. That's what they are saying. For that, my lord, what they submit, my lord, in this objection is there's evasion of PF membership in respect of 6,000 non-enrolled employees. And 198 wards, these are the total Paura Karmikas. Out of 33,000, they are covered 27,000.
Four
If you-
orders. Four orders.
Please.
With your lordship's kindly, may.
Lord, one or two small procedural things, my lord. In the second appeal, writ appeal 967, my lord, we have challenged initially, my lord, the order of attachment only. So other side, my lord, also raised an objection. I filed an application for permission to amend the writ petition to seek quashing annexure A, which is the determination order also, my lord.
That is 26-10-7.
Yes. That's
Lord, may make one submission.
because that is the basis on which the attachment was issued.
But that's, we know that is exactly, we are telling that you can't go beyond contempt unless you challenge.
That's all I'm saying. I respectfully bow down. On the liability to pay, there's no dispute.
But even if we grant that amendment,
Please. Only to the extent of quantification, I request the court to interfere. Not on liability.
even after challenging this order, you are requesting only for contempt.
Please, ma'am.
That is fair enough.
Please.
May make one submission. That's also okay, my lord. I'm not coming in that. But only thing is, 7A order was passed, quantifying the amount and also the liability of the BBMP. That has kept intact. That has not been challenged at all. When that has not been questioned, how the recovery proceedings can be questioned?
What is not question?
7A order, which is the prime order in EPF, whenever there is an inquiry and after the inquiry, they
Council is seeking amendment.
amendment in writ petition, is it ever possible, Milan?
My lord, how it happened was
How is it ever?
the workers, my lord, initially, the workers came
That
to
can
honorable
be done
court.
there also. Because the time limit is only 90 days, that they cannot, it cannot be extended. It's a statutory limitation.
So what is your apprehension
The explanation is
about this?
yes. The submission I'm making is this, my lord. How the list came before the court was, the workers came before the court and they contended that they have not been paid and they sought certain directions. And that is, my lord, the writ petition 16539. This order was passed on 26-10-17.
No, is there any excess payment by you?
There is, my lord. What I'm submitting is, if the record is seen, in regard to all Paura Karmikas who are on our rolls in this period, we have paid. There is, I agree, my lord, there is a lot to be said about how the records are maintained. The main reason being these contractors are involved. So, my lord, after this writ appeal is filed, my lord, we had a series of meetings with the highest level of officers, including the commissioner. They have now collected and collated all the information ward-wise as to how many Paura Karmikas were there. and how many were covered by PF, how many were not covered. So, my lord, what happened when the workers filed the petition? They said there's an order passed, please enforce it. At that writ petition, my lord, we at that stage we filed a writ petition challenging only the attachment proceeding that was initiated. I agree that was a mistake. They should have challenged this main order based on which attachment was issued. That was not done. The learned judge, my lord, went into the whole thing and came to the conclusion that the order is to be sustained. Only, my lord, when we came before your lordships, my lord, that is when this was realized that this is what has happened. After all, my lord, this is a bona fide mistake with the authority. And all that I'm saying, I'm not challenging the liability. I'm only saying, my lord, on the quantification, if there is material, they should see it. That's all I'm saying, my lord. That's why I had to file this application, my lord, seeking your lordship's kind indulgence. My lord, your lordship knows writ appeal is continuation of the writ petition. If I could amend it at that stage, your lordships may consider it at the appellate stage also. And it's only for the limited thing in the extraordinary circumstances of this case, my lord, I being a public authority. And I'm pleading, my lord, that the officers, my lord, concerned who dealt with it were, my lord, you have to use some other adjective for that. Negligent, or I don't know what.
My lord, may I submit, my lord? I represent the union who had approached the court at the first instance. In the amount that has been arrived at is in respect of the amounts due from January 2011 to July 2017, my lord. The order was passed in October 2017. The BBMP, my lord, had in fact written to the PF authorities saying that they're giving a total number of Paurakarmikas on roll. As per the BBMP's own statement, they say that, my lord, 33,752 Paurakarmikas are on roll. This is what BBMP submitted to the PF authorities. The number of Paurakarmikas who were enrolled with the PF, in respect of whom the PF dues were being paid, was only 27,000. It is there for, my lord, the number of 6,000 workers, as per the BBMP's own records, that is 33,700, out of which only 27,000 were the PF amounts had been paid. So 6,000 workers, in respect of whom the PF amounts had not been paid at all. And on the basis of this number, my lord, was the final amount of 90 crores that was actually reached. If we actually look at it, my lord, finally it will come down to around 1,500 rupees per worker per month. That is approximately how much that amount comes down to. If we take 90 crore to 6,000 workers, it comes down to around 1,500 rupees per month per worker. And that they have calculated as per the minimum wages that were due, because that is what the workers were being paid, only minimum wages. So as per the notified minimum wages, this amount has been calculated, my lord. Therefore, my lord, the amount has been calculated only on the basis of the BBMP records, not on anything else. In fact, my lord, the documents that have been produced by the PF authorities in the objections filed by them, that shows that mail that has been sent, and it shows that number, my lord, at page 12 of the documents produced by the PF authorities in their objections dated 12th August 2024. That the objections dated 12th August 24, my lord, annexure R1 at page 12.
So you filed IA for production of documents.
Yes, ma'am. I filed an IA, my lord,
They are
for
the-
production of documents.
they are
And I also sought direction to them to produce documents. They have now, in response to that, produced this. My lord, my documents which I have filed, my lord, there's an IA in which I have filed certain details. This shows, my lord, division wise, how many people were there, who are the contractors through whom this was done, and the returns that they filed. Now, my lord, this what they tried to do is some overall thing, my lord. They say you say 33,000, there's record for 27, difference is what you have not paid, and they computed it. But that doesn't take note of one aspect as to how many were directly employed, how many were through this agency, and how many of these contractors paid them. That data now is available. I have produced them out with my application for additional documents.
Not it is, whether through contractor or directly, it is the liability of the principal employer to collect and pay.
I'm not
And hence
disputing.
we cannot go behind contractors and.
No, my lord,
form
the
them.
law is that the contractor is the primary duty for them to discharge the duty.
That.
And that information is sent to us.
My lord, that BBMP
Para
communication.
And all these are, my lord, they have to register the PF authority. Every contractor has to register. They have to have a PF number. And they have to deduct and they have to make the payment. So they have to do some cross verification.
I'm sorry, para 6, item number 4 may kindly be seen, ma'am. In the Employers Family Pension Scheme, 1990. Employees Act, my lord, para 6 in Employers Pension Scheme 1995 may kindly be seen, where it is very clearly statute refers payment of contribution by the employers. That is, the employer shall pay the contribution. Para 4, ma'am.
I'm not disputing that.
No, when.
I'm
there
not
is
saying
dispute,
that we are not liable. I am admitting I'm liable. All that I'm saying is when there is a contractor,
Para 4.
the contractor is registered, the contractor deducts,
85.
the contractor pays, then he makes a bill to us and we pay accordingly to him, to the contractor. So that verification can be done is all.
My lord, just one more submission, my lord. One is that the order is based on the records of the BBMP. The second thing is this, my lord, in October 2017, the order under section 7A came to be passed. It is an appealable order under the PF Act, my lord. There is an appellate tribunal. And that order has to be appealed within a period of 90 days, maximum 120 days. And beyond that period, there is no scope for condonation of limitation. There is a order of the division bench of this honorable court, which clearly says that it cannot be condoned. That I have
What
placed
happened
along
in
with
this
my
case
synopsis,
was,
my lord.
we filed a
Therefore-
review, my lord, in 2018. And that review, my lord, was supposed to be disposed of. And we didn't get a copy of that order till 9th of February 22. So that also, my lord, I have pointed out.
The review petition.
Yeah.
Yes, my lord, in fact, the review petition which this.
It's more important.
We'll keep in,
Payment of contribution, my lord. 4.
we have seen
Yes, ma'am.
payment of contribution.
Yes, my lord. The employer shall pay the contribution payable to the employee's pension. Did your lordships get it? Item number 4 at para 6, ma'am. Payment of contribution. Oh, ಅದನ್ನ ಅಲ್ಲಿಂದನೇ ಬರೋಣ. ಬರ್ಕೊಂಡಿದ್ದೆ. ಮಾಡ್ಕೊಂಡು ಬಂದೆ.
1950.
ಕೊಟ್ಟ 1995.
52.
1990.
8
ಹಾ. Para. The employees scheme 1995. Para 6. Even section 2F, the definition, an employee, my lord, it is there, that he is liable. And it is nothing new for them because they themselves have produced the documents before the inquiry. That has been forwarded by them. And we have taken minimum wages. We do not know whether they have been highly paid. That is also not reflecting. Note this. ಇಲ್ಲ ಇಷ್ಟ ಹಿಂದೆ ಹೋಗಲ್ಲ ಇಷ್ಟ ಹಿಂದೆ ಬಂದೆ ಎಂಪ್ಲಾಯೀಸ್ ಪೆನ್ಷನ್ ಸ್ಕೀಮ್ ಅಷ್ಟು ಹಿಂದೆ ಹೋಗಲ್ಲ ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ ಅಷ್ಟು ಲಾಸ್ಟ್ ಬರಲ್ಲ ಅದಕ್ಕೆ ನೋಡ್ತಾ ಇಲ್ಲ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇಲ್ಲ Yes. Para 4 make and labissing. Payment of contribution. The employer shall pay the contribution payable to the employee's pension fund in respect of each member of the employee's pension fund employed by him directly or by or through a contractor. It shall be the responsibility of the principal employer to pay the contributions payable to the employee's pension fund by himself in respect of the employees directly employed by him and also in respect of the employees employed by or through contract. So when such being the case, even definition 2F also is very clear that he is liable to pay. Employer is an employee. The intention of the statute, that is Provident Fund, is very clear that those rights under the Constitution which has been guaranteed has to be protected, needs to be protected. And we did not go in search of the employees or because they are directly connected with the main principal employer. If that is the case, it is their obligation to collect the contribution and remit it to the Provident Fund. If in the event, if they fail, that is why they check and cross, because
I'm not disputing
if
that
they
at all.
fail, then
My learned friend need not labor. I'm not disputing
no.
that position.
That is true. But principally they're in. And now the second issue with regard to the quantum or something. Now the quantum is also, it is decided only based on the minimum basic wages which has been fixed by the central government at that relevant point of time. We do not know whether they have paid higher also, because only 27,662 were given. Other 6,000 were given by them only, the employees employed by them through their contractors. So if that is the case, when they have made a statement before the discipline, that is the inquiring authority, that these are the employees working under the corporation, these are secured or permanent employee, temporary employee, or daily wages employee, or through contractor, can they go back and say that the quantum is incorrect? That means, have they not paid the basic wages also? That is the minimum wages also? That is why only with regard to those 6,000 employees who are not been paid or who are not been contributed by the BBMP has been taken into account, and an order has been passed under Section 7A after holding an inquiry. So when an inquiry has been held, if at all they have any grievance, it needs to be challenged before the tribunal as per the statutory provisions. If they fail, Section 7A, if they fail, they cannot go back and say after 10 years that I can go back, 2000, after 6-7 years, because limitation starts from the date of receiving the copy or concluding the. Then second part is review. Review also we have already forwarded, and I have produced those documents wherein the corporation department has received. The acknowledgement also has been produced. It is not that we have not done. If at all they have so much confidential in them, they should have asked at the time only what happened to my review. It is an authority. It is not an individual answerable to the public like how my learned friend says. That is true. We do not say. But these contributions are quantified only on the minimum basic wages. Hence, reverting back, I don't think it will have any result because of the reason that they may have to produce everything. It may raise also. Then second thing is statutory violation. Third is limitation. Then the fourth act is based on their own statement. So admissions need not be disputed. That is what the evidence act says. Much obliged.
Will consider.
Please, Mela.
My Lord, I filed,
For orders on this 29.
please,
Grateful.
my Lord, I have filed a synopsis. It's on the file, my Lord.
You want to file?
I have already filed a synopsis, my Lord. It is on file. No, my Lord, I filed on
If he
26.
wants to file further, it will be filed by tomorrow, not beyond that. Please.
Please,
Please, my Lord, it is on
Please.
the file. Please, grateful.
And I have asked my officers to be present with the original documents also, whatever has transpired. So I'll call them.
Officer is required to present.
Only the thing is because whatever they say that review has not been passed, the review authority is.
Is there any order passed?
No.
No.
My learned friend says, because I had filed that application out of abundant caution, she had requested the officers to come to instruct her.
They did not feel. No, they never said anything.
Question number 16.
Wait, please, man. Okay, for the respondent. Lord, we are in appeal here.
That is
We are in appeal from the decision of the learned single judge. The issue is, my lord, that paragraph 83, and this is also a Provident Fund matter, my lord. The issue is that paragraph 83 of the Provident Fund scheme, which recognizes foreigners working in India, that paragraph recognizes their entitlement under the Provident Fund scheme. The learned single judge has struck down the paragraph saying that foreigners cannot be covered under the Provident Fund scheme only because mostly their salaries are above a certain wage threshold, which is usually applicable to domestic workers. My lord, to simplify things, I've taken the liberty of preparing a very small note which contextualizes everything. It's a couple of pages. May I please hand this across, my lord?
You are for the Provident Fund Commission.
I beg to appear for the Provident Fund Commission.
Your lordship.
If I may invite my lord's attention to that note, because that simplifies everything.
Before my learned friend begins, may I make a submission? Your lordship, my submission is this, that the appellant
Will issue notice.
Lord, I am grateful, my lord. My only request further, I'm sorry I'm taking my lord's time. When paragraph 83 as a whole has been struck down, the ramification is all the Indians, and I'm told by the Ministry of External Affairs, there are around 30 to 50,000 Indians working abroad. None of those people can claim PF from India. Their money is lying with us. Those people are working abroad. They need to claim their insurance, medical benefits, whatever. Those applications are coming to us. They can't be processed. None of the foreigners working in India, they can't access their PF as well. Now, there is a judgment of Bombay High Court, the division bench, which had upheld paragraph 83 already. That was confirmed by Supreme Court. Those decisions were placed before the learned single judge. They are not considered, and paragraph 83 has been struck down on the very grounds which were upheld already, all the way to Supreme Court. So my humble request is, my lord may stay the operation of this impugned decision, because here today is a conflicting situation. Supreme Court and division
Will take up final hearing immediately.
please.
Lord, we are getting emails from elderly people.
Pardon, we understand, but then granting
lord,
of
that is-
interim leave will amount to allowing the petition.
Exactly.
I'm sorry, my lord, I'm
that
sorry.
is-
Granting of interim leave, staying the order will
Yes, my
amount to allowing the petition.
Please.
It would not, my lord.
It would.
Please, it
May,
is.
may I
Please.
explain? May I,
In fact-
sir, just one second, sorry. If anybody's interim amount which is lying with us, according to the judgment, it must be paid back to them because 83 has been struck down. Precisely that is also what is to be happen. If we accept their claims, either ways the money must go to that worker, whether under the,
All are appearing for the respondent.
Lordship.
You are for original petitioner.
May I make a
Yes.
submission?
You are for original
Yes,
petitioner.
yes, my lord.
You
May I
are
make-
for,
I am for Union of India minutes. This is a notification.
what is your stand?
Minutes, my stand is the same. In fact, I'm also going to file an appeal in.
Supporting the,
Yes, sir.
It is the Union of
Naturally.
India who was to file the
so
appeal.
there is no other party.
Other parties.
There are 29, there were 23 writ
Petitions are
petitioners.
there.
A
No,
common
in-
order was passed.
One minute,
Only one writ
1 minute.
petitioner, they have filed a appeal only against one writ petitioner.
I'm sorry.
No, we have
Another
filed.
23
May I
they were
clarify?
deferred.
These are red herrings.
In fact,
I can
showed
clarify.
them
Wait,
Wait.
another.
23 matters are there.
23 writ petitions which were,
It will follow. We'll-
Yes, that's it. Issue is same.
they must be heard, my lord.
So you are agreeing for hearing of the matter?
Yes, man.
All of them must be heard.
All of them.
This appeal may be heard when?
My lord, my first submission is this,
Hmm.
that the appellant himself has no locus because he is only.
Therefore, we are hearing it. Lord learned advocate so and so for the appellant Provident Fund Commissioner, learned advocate so and so for Union of India and learned advocate, respondent Union of India and learned advocate so for respondent one original petitioner. Notice returnable on so and so respective counsel for the parties, the counsel for the respective parties accept the notice on behalf of the client, the petition, the appeal may be listed for final hearing.
Fine.
Well, Lord, I'm grateful.
On 7th of November.
7th, obligation.
So on that, they remind us, we'll take up.
Yes.
I'm so grateful.
Proceed with the matter.
I'm so
Instead of
glad.
considering interim relief, because it will amount to granting principal.
I realize that.
Very
I'm so
appreciate-
grateful, my lord. I'm so grateful. Obliged.
My lords, morning, today the matter will be taken up, they had told, and taken the posting memo, but they've put it for tomorrow. So today auction is there, my lords, kindly, since it is complete.
But ವಕಾಲತ್ತು ಇದೆ ಅವರು.
Ma'am, 28 have they taken adjournment?
Thank you also. I'm 17.
ನನ್ ಕುತ್ಕೋತಾರ ಜಡ್ಜ್ ಲಂಚ್ ಆದ್ಮೇಲೆ
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಲ್ಲ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
Council submission.
2:30 matters.
ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
230 matters ಎಲ್ಲ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ ಅಲ್ವಾ? 5th time per.
ಮೇಡಮ್ 24 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಚೆಕ್ ಮಾಡಿ. ಮೇಡಮ್ 24 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ
So continue on the 30th. Sir, continue on the 30th. 30 continue.
ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಓಕೆ ನಮ್ದೇನು ಚಾನ್ಸ್ ಇದೆ 2:30 ಇದೆಯಲ್ಲ ಒಂದು 20 ಅದಕ್ಕೆ ಚಾನ್ಸ್ ಇದೆ.
2:30 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಚಾನ್ಸ್ ಕೊಟ್ಟು ಹಾಕಿದ್ದಾರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅದ್ರಲ್ಲಿ ಒಂದು ಮಾತ್ರ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಮೂರೇನ್ ಮಾಡಿದ್ರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಸೆಕೆಂಡ್ ವಿತೌಟ್ ಪರ್ಮಿಷನ್ ಸೀಕಿಂಗ್ ಪರ್ಮಿಷನ್.
Yes.
But serial number 42 is covered by a decision of your lordship's board. Object to your lordship's convenience sometime not next week of the at the earliest convenience may be your lordship's.
It is covered.
It's covered.
Lie, what is that?
Because my lord, the AG was supposed to come, my lord. Last time they took time saying AG has to come.
ಕೇಳ್ತೀರಿ ಏನೋ ಹೇಳಿ ಒಂದ್ ಎರಡು ಮಾತು ಹೇಳಿ ನೀವು. ಎಷ್ಟು? 42, madam.
It is a red petition. Green bench.
Yes,
Green bench.
Green bench. What had happened was, my lord, there was that option by, my lord, by means of the orders of the Supreme Court. They were to give us, my lord, all the permissions and sanctions. They did not give that permission. Thereafter, my lord, they levied some fine. Under similar set of circumstances, another, my lord, MSPL, the lordships will not have quashed that fine that was levied because they did not transfer that permit.
Whenever you want.
Subject to your lordship's convenience.
But we are not recollecting by which order it is covered. It is covered.
My lord, that's my submission, brother. So they'll have to.
My lord, the AG is appearing in this matter. I'll have to seek instructions as to what the matter is because my colleague attends the.
On 8th of November,
Please, at 2:30, my lord, subject to my lord.
2:30. Provided it is covered, otherwise
Yes, sir. I'll point out.
to be argued, then,
No, I understand. We understand.
then we'll, if possible on that day, otherwise
Very.
Please, my lord.
8th of November. List at 2:30, list at 2:30.
Lords, may make a mention regarding serial number 103, my lords. Three. Lords, appellants have made a mention and therefore the matter is listed, my lords. Appellants have pleaded urgency and therefore, your lordships, can I seek for 1 day's accommodation, my lords, either today or on Monday, my lords. Monday at 2:30, I could not. Monday, my lords. The elections is on 4th, my lords. The calendar of events is published. Election is on 4th. 28th, I'll argue the matter.
Wise people never mention 103. So it will go.
Fine.
Not likely to be taken.
Very well.
What is the urgency?
My lord, from Monday, my lord, the election process is going to start.
Oh.
What, yesterday,
Lords, calendar of events has already been published.
In 2:30 list, that's,
my lord, that is why.
you want time.
Lords, the elections is on 4th, my lords. If your lords is were to accommodate on 28th, my lords, I will not take any adjournments on 28th. Lords, election process is already commenced. My lords, once the calendar of events is published, election process is deemed to have commenced. Your lordships have already taken a view, my lords.
Tomorrow?
Tomorrow, my
Not
lords.
tomorrow, 28.
28 minutes. Monday afternoon, I'll.
In the minute, in the first session will take.
Very well, my lords.
Monday in the first session.
Please.
This will start, my lord. Again, there will be something.
No, it's
Tomorrow-
already started.
What's your name, Mister? Tomorrow again you will face same difficulty.
Tomorrow, your lordship is having the
I-
difficulty, my lord, tomorrow.
I-
The request for tomorrow.
If tomorrow in the first session, Mr. Ravi Shankar is agreeable,
I'll come, my lords. I'll be before your lordships.
tomorrow,
I'll come.
tomorrow,
Very well, my lords.
notify.
It could be 28 minutes because 16th, the calendar of events is published. 18th, they have filed the writ appeal. Lords, 1 day because I need to prepare, my lords. That's the reason why. 28th, my lords. I'll be before lordships at 10:30.
When matter recalls, my lord, there is already, yesterday, therefore he mentioned it. my lord.
28th, my lords, because the elections are scheduled on 4th.
There is
The
another
elections is on
therefore we have
4th.
made The writ appeal, my lord.
Lords, the elections is on 4th. I'm not seeking, my lords. 28th, I'll argue the matter. There'll be another 3 working days. 28th, I'll argue the matter in the first session itself. At 10:30 minutes, I'll be before your lordships.
Let us open today for his satisfaction.
Yes.
Will
10
not,
minutes, my lord, before lordship.
will not conclude, nor will speak anything.
Then instead, it may be taken up tomorrow because I couldn't get ready with the papers for.
Yes, you don't do the paper.
That is the reason, my lords.
Tomorrow 2:30 may not be possible. In the first half, yes.
I'll be there in the first half itself, my lords.
Very,
Please.
Please.
Serial number 101, my lord, sir. Filed a memo for withdrawal.
101. You have filed. Law and Advocate, so and so stated that the memo of withdrawal dated so and so file, which is on the record, full stop, in the memo, dismissed as withdrawn.
Serial number 99, my lords. We have filed a memo for withdrawal of the case.
Oh, clear. Clear.
Serial number 99, my lords. We have filed a memo for withdrawal of the case, my lords.
Already filed.
Yes.
99, same order.
My lord, serial number 38, we have for respondent number 4. My lord, it's quite voluminous and the concerned counsel, he's held up in
that. Let the matter reach, my lord. My senior is on.
my lord, just seeking a short accommodation of next week.
Serial number?
Serial number 38.
Serial number 38, we have for respondent number 4.
even mentioned, informed us, just came and mentioned.
My lord, the concerned counsel
Let it
is
be
in
taken
the
up.
special MPMLA courts right now.
PIL. It is PIL, no. It is not submitted. 38.
38.
No, which one? Which one?
Number 38.
38.
Yes.
38.
It is not. Yeah.
Portal operators, treasurer operators.
The Safari met.
I
Fine,
found-
yes, madam.
Yes, madam.
What is the urgency?
And there's been discrimination in the allocation of vehicles.
That's a merit.
That's a merit, ma'am. So it may be taken up during the course of the day when it reaches.
But your
This-
colleague wants time.
5th of November, sir. It's
And it's
fine.
their affidavit, which they filed the data. We just filed a calculation of that. I don't know what more they want to file regarding it.
Just a short accommodation, my lord, of 1 week's time.
The date may be 28 or 30 maybe.
40.
5th of November, sir.
5th of November, no. 5th of November, there's some incoming.
20. 28th, my lord. 28th of this month.
28 not possible. 28 is not.
30th is, I can call it in. 30th, my lord.
30, the joint request of learned parties stand out to 38. Yes.
May not be required as joint request, their request. We are okay with the matter being taken up today or normal court.
Stand out to 30th October, comma, as requested. So nobody knows who is requested. Yes.
Number 30, my lordship, is maybe timely taken up Monday.
One day not possible. 30th, 30. 30. What is it about? Monday is not, either today or in the week of contempt. Seventh November.
Period number 24. 1 week time maybe. 1 week time maybe.
But nobody is proceeding with this commercial appeals. Why? 1 week.
1 week time maybe.
So we will engage senior counsel within the time you are seeking for. Then senior counsel will read, then prepare, then again will come a time in some other court. Then again, all like whenever you want, which date you want, at the request of learned advocate of the appellant, stand over to
7th or 8th.
20th November. 20th November. From as requested. Now, withdraw. Hearing.
$230 matters. serial number 100, Shanant Narayan BN for withdrawal.
Okay. Memo dated 25/9/24, figuring on record of the present proceedings, reads as under, which is filed by the complainant. So, quote the memo. In view of the memo, dismissed as withdrawn.
101 dispose, serial number 102, to Vaibhav Ravi Malimat. One zero three urgent. Serial number 104, Shashidhar Prabhu.
Yesterday I had submitted that the petitioner before the learned single judge was not an aggrieved person at all. He had no locus standi to even question what has taken place under as per law. Under the Public Procurement Act, Karnataka Public Procurement Act, the two-fold system was adopted in accordance with law. It has been given and the publishing has taken place on 24/1/24 as per Annexure A, page 65. Subsequently, the tender has been approved and awarded in favor of the concerned respondent whom I am representing. Subsequent, much later, the process, the work order was said to have been issued on 16/3/2024. Incidentally, on that day, there is a election commission letter which my learned friend had produced freshly before this honorable court. This contention has been taken up before this court for the first time. And that is not even the subject matter. Anyway, in page 401, which I read and pointed out, my lord, these works can start only after completion of election process. However, if a work has actually started, that can continue. My respectful submission is, as far as this tender is concerned, under the Contract Act, the tender has been issued and it has been accepted. There is no dispute of this. His grievance is that he was kept away because he was a class 1 contractor. Both could not have been joined together and awarded to the in the form of tender. That has been not that criteria to award two-cover system is found in the Act itself. Two-cover system is found in the Karnataka Transparency in Public Procurements Act. It is not illegal for the authorities to issue the two-cover system for two purposes because it's all combined. Now, if for example, this is the purpose of this is very clearly mentioned. The tender covers construction of improvements to median under the BGS flyover and providing street lights and so on and so. So this will be because if a civil contractor takes it, he has to even construct that BGS flyover. Providing street lights is only a smaller work compared to the larger work involved in regard to BGS flyover. So if person who is taking up that contract, if he is capable of doing the work which he has to do, which he will know where the ducts are, the electric wires are and all. If they give it to another person who is a contractor as they dictate terms and direct us to give it to an electrical contractor for that work, that it will be a clash of interest and there will be no proper assessment of work. It will delay. My humble submission is much water has flown since 24/1/24. Almost 90% or more of the work has been completed. Almost 90 to 95% or even more because 6 months have lapsed. The work has been proceeded with in accordance with the terms of the tender. Now the question of stalling it at this stage through this process is only to cause threat, nothing else. And these people are not having any locus stand. He's not aggrieved at all. He's not an applicant also. That may be appreciated. That kindly see there is absolutely no illegality committed in the Leonard single judge's order. Judge order.
My lord, on the last date, my lord,
May I read the single
a
judge's
specific
order?
submission was made. If the work has started during the election period, then, my lord, they have no case. Kindly see, my lord, the work award at annexure Q, my lord, 287. And kindly see the date of the work order, 16/3/24.
Why don't you take rest?
No, no. And this is the date of the announcement of the code of conduct. Annexure Q 287 is the date of the work order. And unless the work order is issued, the work doesn't commence.
When work order is?
16/3/24, annexure Q 287.
16/3/20.
Yes. And now your lordships may kindly see the date at page 400. Page 400. Yes. Yes. 400. Specifically, the date on 400. No? Same date. Just hold, my lord, annexure Q and juxtapose with page 400, the code of conduct. Same date. And they fairly conceded that if the work has commenced, if 80% of the work is done, it is done after this. They conceded, my lord, if both are same, then they have no case. And it was revoked on 6th June, my lord, which your lordships will get at page 404. 404. So until the 16/3/2024, up to 6th June, no work would have commenced. If they have done the work during this period, they are in violation of the code of conduct and their own submissions made before your lordships. And the primary submission remains, Lord, that I am an electrical contractor. The work is an electrical contract. And as per the Electricity Act, there are safety requirements to be complied with, and electrical work can only be done by an electrical contractor. If they merge it and assign an electrical work to a civil contractor, that in itself is, my lord, a vitiating factor for the entire tender. And third vitiating factor is that a company is a separate legal entity from its shareholders or directors. If the directors and the shareholder and the company combine together and, my lord, participate in a tender, then that itself vitiates the whole thing. Then, my lord, any individual can float a company, transfer his license to that company, yet participate and be a qualified tenderer. So he qualified. Ultimately, my lord, the tenderer is the person who had transferred that work license in favor of a company. And second bidder, the single bid is my specific submission, because that second bidder, who, my lord, participated as a dummy bidder, got his license itself in 2020. And the requirement was previous 5 years qualification works had to be produced. So there was no way that he could produce previous experience certificates, my lord. And last submission is the PMC contract holds the key. Now, as per the PMC contract, which, my lord, is the basis for commencement of work and a guidebook for the contractors. Why the PMC contract was issued in June is because no work would have been conducted between March and June. And therefore, my lord, the work PMC contract itself comes in June, because there was no requirement for project monitoring itself. Annexure T, page 340, may kindly 340, my lord, may kindly be seen, which 340, my lord, A, 5.2 A, my lord, on page 340.
Now, kindly see my lord the background first, 340 nalli. BBMP is desirous of obtaining, providing PMC services, including, I'm sorry, what I'm reading, including supervision. Sorry, my lord, I'm not reading with your lordships.
340.
340.
5.2, yesterday you read it.
Yes, ma'am. That's all I'm reiterating. I'm saying I'm just reading the previous paragraph. I read that particular requirement which says monitoring. This is for that very work for duration till the completion of the project. So the PMC contract is not the heart of the matter. The commencement to end is the responsibility of PMC contractor. If he has executed the work not in supervision under the PMC contractor, then my lord, the contract goes. And a wrong submission was made. When the code of conduct was in vogue, they come before the honorable court and say 80% of the work was done, not disclosing that there was an embargo placed under the placed by the code of conduct, wherein they could not have, there was no delay. The only ground on which, my lord, I am unsuited is that I approached late. Now, if there is a code of conduct and if there is an embargo, specific restriction not to undertake work, and when the PMC contract itself is not finalized, it's only issued. Even this is not finalized, subject to what, my lord, my learned friend from BBMP has to say. The PMC contract was not finalized. There was no reason for me to believe or anybody to believe that work would have commenced, much less completed 80%. So this is the scheme of things, my lord. And this sets a very wrong precedent where single bidders, lordships may see the symptomatic aspect, my lord. A single bid contract is styled as a multi-participating contract where there is no other tenderer will not have qualification. He will simply bid. They will allow him to come in. Even if he has experience of 2 years, 3 years, they will allow him to come in and make it look like it is a complete tender where multiple entities have participated. And look at as if there is competition and then give that contract on the date of code of conduct and say that 80% work is done. And most importantly, my lord, I rest my case by saying electrical work cannot be clubbed with other works, particular civil work and some other work can be clubbed. When there is a statutory embargo, statutory restriction to undertake a particular work for electrical contracts only under the Electricity Act, because this is a licensed function. If an electrical contractor has to pass a test, there is, my lord, special wiring permit rules framed by the government in 2012. In every state, my lord, this is in vogue. I have to pass that examination to be qualified as an electrical contractor. If I'm a class 1 contractor, particular work, class 2 contractor, particular work. So if I am not qualified, I cannot undertake. Now what, my lord, the respondent will do, the private respondent before your lordships will do, is that he will entrust it to some other third party. There's again a partnering, that he will take another electrical contractor and participate. So this is, my lord, the whole scheme, which has entirely vitiated. That's all. Grateful.
So we are reserving it, heard learned advocate, so and so, with so and so, and standard format. And at length, the respective parties stated that the pleadings are complete. They argued finally, pleadings are complete, and no further are required to be added or supplemented. Reserved.
Grateful.
My lord, one submission, but your lordships have already, it is the.
You are there.
Yes, my lord, already, my lord, kindly.
Right through the tender.
In writ petition number 381 of 24, my lord, Larsen and Tobro, the similar facts and circumstances, my lord. In the similar, your lordship's decision, my lord. Yes, my lord. Yes, my lord.
One request is 404 page number documents is kindly.
Lord, I will read that only 2 minutes, my lord. I take only 2 minutes. In the similar circumstances, my lord, what has happened? This what happened?
Right, unbefore. What is this?
Lord, in this case, what has happened? Kindly turn to page number 6, my lord.
6. Who are you? You are.
I am for the respond number 192, my lord.
And 2. So then 1 and 2 must have been heard first.
Yes,
Why
my lord, but because senior is engaged by the respondent, lord, I have given priority to senior.
Seniors should be heard first.
Please.
Who is one?
Who is the
BBMP chief.
BBMP, my lord.
Chief Commissioner.
Chief Commissioner.
Chief Commissioner, the most important.
Most important.
Yes.
My lord, see. Lord, what has happened? It is nothing but an abuse of process of law, my lord. What has happened, Lord? Kindly see the actually work was called for not for electrical work. It is a civil work, my lord. Annexure N, my lord. Annexure N says improvements for the BGS flyover, my lord. In that, only small work is, even it is not a work, my lord. Providing street lights. Only in that respect, electrical work is, it is only to provide LED street lights, my lord. Except that nothing, my lord. Majority of the work is for the improvement of the flyover. And bus shelters, my lord. To provide bus shelters on the flyover. Fourth one is, my lord, name boards, street name boards, my lord. Out of which, what has happened? Only LED, for the purpose of LED, but to provide LED bulbs, the BBMP cannot give a separate tender because 90% of the, because of the coordination of the electrical contractor and civil contractor may differ. They may say something and civil contractor may say something. Therefore, for the coordination and practical purposes, they have given only one tender. And there is no prohibition, my lord. The learned counsel for the petitioner, either before in the writ petition or in the writ appeal, they don't say where is the prohibition to club these two. In case if it is a electrical contract law, if it, I'm not a representing KPTCL. If the KPTCL or Power Corporation calls for tender, then the appellant has a case law. It is a the civil contract is given only for the providing LED bulbs. I cannot call for electrical contract. That is the reason, Lord. The other thing is, Lord, now without taking contention or this regarding election, Lord, there is no ground in the writ petition, Lord. Election, the model code of conduct regarding the grounds, they have not raised any contention, though kindly say, my lord, the trial, this learned single has rejected dismissed the writ petition on the ground that actually the process has been completed March 16th, my lord. March 16th, 24. But the writ petition is filed on 22nd May 24. The work has been started in March 16. Now the petitioner files after results have come. After Lok Sabha elections have come, the writ petition has been filed. Therefore, my lord, the learned single judge said the petitioner has approached after the issuance of work order and completion. Majority of the work to the extent of 60% was completed when the objections have been filed, my lord. Now, even assuming that for the sake of argument, my lord, if that contention is taken into consideration, these process have been started in December 23, my lord. This contract, it is not started in March. This is government approval and all proceedings. The appellant has produced all the record, my lord. Only thing is, work order has been issued on 16th March. After that, the work has been started.
Only one request. The petitioner himself participated in a tender for electrical work and his application was rejected. He goes to the court and he files the case saying that the entire process is wrong. I was not given sufficient time and whatnot. Similar petition he was dismissed. For this very work.
No, my lord, that is
some other work, some other
Conduct.
How it is?
It's only a litigant.
Yes.
My lord, in the
I'm of course, I admit that I have participated in that litigation as well as.
My lord, in this case, I have given this writ petition, lordship's decision, that was upheld by the apex court. My lord. That was also given me.
Yes. No, Lordships may take notice of the fact that my lord, the work order is issued on the date of election and work has started and 60% work was done during the vogue when the election, this one was vogue, as per the previous one. Page 10, my lord. Lord, page 10 I have put.
Yes, humble request. We have all been led by page 400. In page 400, what is shown is that the work order is pertaining to Andhra Pradesh, Arunachal Pradesh, Odisha, Sikkim, and certain by-elections. Doesn't concern.
Lok Sabha elections.
No,
The elections was held simultaneously.
However, if a work has actually started, that can continue as per what I read out. The last submission is, election commission, their own document at page 403 says in page 402 and 403, that on 22/3/2024, it will be published. Yes. So it is not as if it comes into effect immediately. 22/3/24, it will be published. And the work has already commenced as my brother colleague submitted. And here is a person who is always litigating unnecessarily and troubling his BBMP and others.
Page.
Who want to do something and see that the work is completed.
That electrical rule, my lord, is at page 10. Your lordships may see the page 10, my lord, is the exact rule. Even private houses, my lord, we need a contractor, a licensed electrical contractor, not KPTCL works.
Now
Even-
eagerly await 29th or whenever it is.
Great.
Great.
Copy ಕೊಟ್ನಲ್ಲ ನಿಮ್ಗೆ.
Subramanya R.
Here term is over.
Not yet.
No.
Term is not.
Not over.
But there is a clear, very clear provision in the section itself.
The lordship were pleased to dismiss the university. They went to Supreme Court confirmed your lordship judgment in that matter.
The Rajiv Gandhi.
Rajiv Gandhi, which is a connected judgment in this matter.
From which the
Judgment
writ appeal arises.
arises. So therefore, in this case, the subject in this case also, as the lordship pointed, doctrine of pleasures is incorporated in the provision itself. So in that sense, it covers.
1 and 2.
But the only slot of argument for them is that even if there is a doctrine of pleasure incorporated, you can't arbitrarily do away with the services or the.
Yeah, man, okay, lordship, we kindly see the provision in this matter. Man.
That is how the the Indian judgment goes.
Indian judgment goes.
So that you have to answer.
So, no,
Even if there is a doctrine of pleasure applicable and expressly stated,
in fact, that's.
arbitrarily you can't do away with
It's
it.
not arbitrary, Manoj. It's
And
which.
that too, my lord, whatever is done in the previous government, I don't know, government is one and the same. Previous, the
But if
order says whatever is,
the statutory section itself so provides, probably in this case. Section itself so provides.
the section, my lord, this is slightly different compared to that other
We
provision.
checked.
Sorry.
Lord, kindly see the provisions under this is at page 104 is the provision.
What it is, what are like this? So many documents, so many documents.
It's a page.
That is not exclusive. That is not exclusive. This is the bond.
Section 4, Central Relief Committee.
Section 4, subclause 2. The committee shall consist of secretary to government, director of social welfare, secretary to government, 4 non-official members nominated by the government. Government may appoint one of the members to the committee as its chairman and appoint a secretary who may or may not be a member of the committee. Now here, the appellant was appointed as a chairman of, not only a member, he was appointed as a chairman, which is at page 117.
This is 2 appeals or 1 appeal?
What? One appeal.
One was already.
It's a combined,
Appeal.
This is a connected matter, Manoj.
Oh,
The other appeal was disposed of, but common judgments.
At page 117,
So this is now we are concerned with this 10994.
104, my lord.
10994. Where petitioner is Basavaraj Nayak
Yes, yes.
Correct.
and Central Relief Committee,
Yes,
MS Building.
yes. Only for that.
So Rajiv Gandhi matter is over. Now, where is the discussion as far as this matter is concerned in the order, impugned order?
Page 20, man.
Page 20.
Para 6 at page 21. Huh? Para 3 also gives the facts.
Common discussion is.
Then page 26.
Page 26.
26.
The reasoning is at page 72, para 20.
Where is that section? Central
But you'll also page 26, Manoj. Page 26.
is reported.
Page
No, it
26,
is,
clause
act,
4,
act itself is produced
page
at page
26.
104 is the statute.
Subject to the pleasure of the state government.
Please, Manoj, clause 3.
The statute are produced.
So here what happened? Let us go to the petition.
Blood, this, the appointment is on 26/7/22. Then the note of the removal is based upon a note of the chief minister, which is at page 119. At page 120 is the translated copy. Kindly see this. Note, page 120. It is hereby directed that to cancel the nomination of all presidents, directors, members of all boards, trusts, autonomous institution and other government, quasi-governmental and other units of Karnataka state government made during the tenure of the previous government with immediate effect and to issue orders accordingly. This is followed at page 97. On the basis of this direction, translated at page 98. page 98, they refer to this note. In the note number dated 22/5/23 of the respected Chief Secretary to Government, instructions have been issued to cancel the nomination of all presidents, directors, members of all boards, trusts, autonomous institutions and other government, quasi-governmental and other units of Karnataka state government with effect from the date 22/5/23 and to issue orders accordingly. It is ordered that the nomination of Shri so-and-so as member of Central Union and his appointment made as president made under 4 and so is hereby cancelled with effect from
So which judgment will you rely on?
Lord, this
Any judgment?
we may mainly rely upon the learned judge himself has referred to this judgment. One is, my lord, at kindly see page. One is BP Singhal's case at page 34, para 17. I have a copy of the judgment also. Or something. Again, brother, is there? Para 34 of the judgment. In fact, that is also extracted at page 44 of the judgment, for that impugned judgment. At ink page 44. The extract from BP Singhal's case. Digambar Kamlan.
Where is your nomination order?
Yes. At page 117.
117.
117, annexure D.
So it was until further order.
Yes, until further order. Immediate effect and until.
So Mr. Advocate General, he will be at the pleasure of the governor or appointing authority.
Appointing authority, that's the
Governor, government,
No, that's
in the name of governor,
in the name of governor.
appointing authority government.
Yes.
So doctrine of pleasure operates for governor or
The government.
so then the political incumbent with a pen stroke of pen says that remove.
The way they come, the same way they go, Malad. It is not that they are selected on the basis of merit or they have any right over it, Malad. It's not that their selection process is gone on, interview is held, marks were looked into. They came through the back door, they go through the back door, Malad. No
So-
vested right.
Now in this judgment, it is singular or what? Single.
Please.
Have you examined the provision? What was the provision?
Malad, in fact,
It's in BP single. What kind of provision was there?
that is the governor. Malad.
Appointment of governor.
Appointment of a governor.
What was the governor?
Governor, Malad. Russians should get it. That is
Governor also-
Article 156, interpretation of Article 156.
Governor
Then
also
this
no
paragraph.
Malad, therefore, Malad, reading from the statute as well as its appointment order, Malad, it is during the pleasure and until further orders, Malad. So therefore, Malad, it is the section itself says, Malad, it is during the pleasure. And the appointment is still until further orders. You cannot claim more right than what was in the statute, Malad.
Now it's page 38,
Please, Malad.
paragraph 22, which is the
38.
something quoted from BP single. Read it.
Please, Malad.
They will rely on this observation.
In fact, Malad, all the judgments in Karnataka, Malad, division bench judgment refer to BP single and Uday Kumar judgment say that this principle does not apply at all insofar as this case is concerned because that is appointment of a governor. Those judgment principle does not apply here. That is what the courts have said, Malad.
So here what will apply?
The statute will apply. Because that is the interpretation of the constitution removal of a governor, Malad. So therefore, Malad, even in a case where general order is passed to go, it is ultimately the policy decision of the government is what just your lordship may kindly the series of judgment. Give the copy to where's the compilation? Where is this? This one? This one? No. Okay. Your Lordship, the first proposition, it is crucial to assess the method of selection nominated candidates to examine whether they will have security of tenure. This court, my lord, has said that there are no security of tenure at all. I may be permitted to read the state of UP versus the appointments made, therefore, made on the consideration other than merit. There exists no provision to prevent such appointments. The method of appointment is indeed calculated to ensure that the meritorious alone will always be appointed, or the appointments will not be on consideration other than merit. In the absence of a guideline, the appointment made purely on personal or political consideration and be arbitrary. That being so, those who come to be appointed by such arbitrary procedure can hardly complain if termination of their appointment is equally arbitrary. Those who come
by the back door have to go by the same door. This is more so when the order of appointment itself stipulates that the appointment is terminated any time without assigning any reason. Such appointments are made, accepted, and understood by both the sides to be purely professional engagement till they last. The fact that they are made by public bodies cannot vest them with additional sanctity. Every appointment made to public office, however made, is not necessarily vested with public sanctity. There is therefore no public interest involved in saving all appointments, irrespective of their mode. From the inception, some engagements and contracts may be the product of operation of the spoils system. There need be no legal anxiety to save them. The next proposition, serial number 2, Qureshi judgment. Doctrine of pleasure is implicit in the statute. When any right of a creature is in a statute is curtailed by very statute, and the person whose right is curtailed cannot claim any right based on the principle of natural justice. Next, Malod, with regard to nominated members having no vested right, Malod. The right to seek an election or to an elected or a nominated to a statutory body depends and arises under a statute. The initial nomination of 2 women members itself depends on the pleasure and subject to satisfaction of the state government. If such nomination made initially by nomination are based on political consideration, there can be no violation of any provision of the Constitution in case of a legislative authority. The legislature authorized the state government to terminate such appointment at its pleasure and to nominate new members in their place. The scope of judicial review, my lords. Such then is the nature of nomination. They are to be made without following any transparent or objective process of selection or those vying for such nomination. They hold good during the pleasure of the government and therefore strenuous lacking credibility or security of tenure. The intensity of review of any decision relating to making or unmaking of a nomination is thus to be low and broadly speaking limited to finding whether the impugned decision is vitiated bad faith, manifestly absurdity or improper motive. Then one other aspect, what is saying is
now the pleasure doctrine will apply only in respect of appointments by nomination.
This is a nomination.
And in all cases.
In all cases.
But then whether it is nomination or no nomination is of no relevance. Because this doctrine will be applicable only in such cases where they are nominated.
He is a nominated person.
So because they are nominated, it will apply or not apply, it can't be considered. The nature of appointment is nomination. There cannot be a criteria to judge whether the termination was right or wrong.
No, what the...
So you are saying that since they were nominated, they had no right.
If there is a regular
That's what the Supreme Court has said. What the Supreme Court has said, because they are nominated.
Regular appointment, there is no doctrine of pleasure.
Correct. So therefore, the fact that they are nominated, there is no selection process, there is no vested right. That is what the courts have held.
But then go to this paragraph at page 20.
No, that is why they have distinguished this judgment, my lord, BP single. Your Lordship may kindly. Can I request, my lords, page 63 of the compilation, my lords? Maybe that article is in the judgment. This they were given you. Your Lordship, what your Lordships are asking is in page 64 may be kindly seen, my lords. What your Lordships are asking that has been addressed by the division bench of this honorable court concerning BP Singhal and Uday Kumar, my lords, whether with regard to nomination, very question was answered by this honorable court.
64 or single judge.
Can I read page 64, my lords? Page 64. Para 17, my lords. Page 64, page para 17. The Honorable Division Bench of this court in writ appeal numbers in State of Karnataka, Dr. Deepthi Baba held that in the absence of any specific provision in the Act for removal of the nominated members prior to the reconstitution of Senate or Syndicate, the provisions of section 21-24 of the Act has to be read along with 16 and 21 of the General Clauses Act. Therefore, the state government has the power to recall the nomination of the person nominated to the Senate or the Syndicate, even therefore reconstitution of the Senate and Syndicate in entirety. As observed above, the V2 Act does not contain the clause of removal and so on, so on, so on. So then paragraph 8, my lords. 18, paragraph 18. The learned counsel for the petitioner relies on the judgment of the Honorable Apex Court in BP Singhal. The said judgment does not come to the rescue of the petitioner in any way. The said judgment was considered in the context of removal of a governor of a state. Governor is appointed by the President and Article 55 of the Constitution of India. The governor will act as the link between the union government and the state government. In the case of so-and-so, reported in so-and-so, district government councils were appointed following the instance of the notification, prescription and qualification and experience and preparation of panel, etc. The procedure prescribed by the legal remembrance manual was scrupulously followed while making appointment to the officers of the government council. In the instant case, it is not a case of petitioner that application was called for from desirous educationists from being nominated to the members of the executive council. The judgment placed and relied upon by the learned counsel are not applicable to the present case in hand. The coordinate bench of this court in A.M. Bhaskar versus so-and-so reported in so-and-so has considered the judgment of the apex court and referred to held that the said judgments have been rendered in the case of appointment and not nomination, and further held that the petitioners have no legally vested right to demand that they be continued as a member of the syndicate for a fixed period of 3 years. The petitioners are neither elected nor appointed, they are nominated, and they will hold the office so long the government does not withdraw its pleasure. The said decision is aptly applicable to the case in hand. The learned senior counsel for the petitioner submit no reasons has been assigned for the withdrawal of the membership of as assigned for withdrawal of so and so, so and so, and so and so. Then, my lord, therefore, my lords, the judgments which have been referred to, either BP Singhal, Uday Kumar, therefore, they distinguish between appointment, elected, and nomination, my lords. Can I request my lords to kindly turn to page 72, my lords. Code of Constitution.
What is the language of article which?
Please, 155.
Appoint the governor.
153, 156, my lord. Article 156. The governor shall hold office during the pleasure of the president.
So in this context of the article 156, where this phrase occurs at the pleasure of government, this single is delivered. Judgment in singular.
BP Singhal, absolutely, my lord. So therefore, those principle is not applicable to a statute which clearly says, my lords.
Here also it's the Constitution says. 156. At the pleasure of the.
No, this, your lordship may kindly see, my lords, what they say is, it's clause 3, my lords.
No, that's right. So same phrase is employed in 156 also. In respect of appointment to governor.
No.
So.
Just keep,
Subsection 3 says that
Subject of, the governor shall hold office for a term of 3 years, the date on which he enters. So the period is
No,
of
you read
Article 156(3), my lords.
156(3).
Subject to the foregoing provisions of this article, the governor shall hold office for a period of 5 years from the date on which he enters upon his office.
No, very first 156(1).
No, then 156(3) may be seen, my lord. There, he says he holds to the pleasure of the president, but tenure is for fixed for 5 years. Whereas your lordship may see this provision, my lords. Here, my lord, if that in.
156(1), governor shall hold office during the pleasure of the president.
Correct, my lord. Having said that, subclause 3.
Correct.
This is fixed tenure for 5 years. 5 years.
So here it is not there. That is what you are saying.
Please, your lordship may kindly see page,
38.
please, your lordship, page 26, my lords.
Sorry, 26. Subject to the pleasure of the state. government,
State
term of
government, the
office-
term of the, therefore pleasure, the term of 3 years is subject to the pleasure. In fact, my lords, can I request, my lords? Which way is that?
Hmm?
Here's the full copy. You have a copy here. Maybe if you find the judgments to the court, the TM Bhaskar. Have you find the judgments? No, where is the Rajiv Gandhi University judgment? That is what, which is that? No, where is this? That is here. What? Where is the Rajiv Gandhi judgment? Deep power you have. You got two copies. Manoj, court has analyzed BP single, various division bench of this court, Manoj, has analyzed BP saying that, Manoj, the post of governor interpreting the constitutional provision of Article 156 does not apply while interpreting a statute, Manoj. In fact, your lordship, all these judgments has been considered, and your lordship may kindly turn to page 57, Manoj, for a moment. Page 57. Your lordship may kindly turn to page 57, Manoj.
57 of this compilation.
The appeal memo, Manoj. In the middle of this, middle of the apex court, Manoj, the nomination by itself from its nature. is
Judgment of non-assisted government leaders appointment.
Please. Please, my lord, that,
Which is that judgment, non-judgment?
that is Uday Kumar. Uday Kumar, right? State of UP versus, I think I put that part of the compilation. my lord. First judgment, my lord, which your lordships have it in my thing. State of UP versus law, state law officers. Your lordship may kindly see me.
Overhead, will find out. Yes, what you are saying, P7.
What your, in fact, my lord, what your lordships say, that is my compilation, my lord. That may be the.
We'll see, find out. Now you are showing page 57.
Page 57, my lord. The apex court holds that nomination by itself from its nature is that the nominees do not have any vested right to continue, as it is not akin to a fixed tenure as found in the statutory appointments. A division bench of this court in the case of State of Karnataka versus Deepthi Vawa held as follows. A nomination to the Senate or syndicate, this is pertaining to the first matter which your lordships were pleased to dismiss, writ appeal, your my lords. A nomination to a Senate or a syndicate is made from certain category of person, namely person having special interest in so and so, so and so and so. And a person nominated either to a Senate or to the syndicate does not have any vested right to the post. Their nomination is only an honorary nomination and is without any financial benefit. It is pertinent to note that plea of vested right to hold a nominated post has been rejected by the Supreme Court in the case of so and so. It is well settled legal proposition. The rights created by a statute can be only limited or curtailed by such statute, and in the absence of some other competing rights under the statute or under the Constitution of India, a right to hold the post cannot be claimed. It is equally well settled that the proposition of doctrine of pleasure can be impliedly read in a provision, and once doctrine of pleasure is applicable, neither the principle of natural justice or giving an opportunity before removal would arise. It is pertinent to note, taking into account the fact that the appellants have been nominated to the post in question and do not have any substantial right to hold the post in the absence of a minimum tenure being prescribed under section so and so, the doctrine of pleasure can be impliedly read into section 21 and 24 of the Act in the absence of specific provisions of the Act for removal of so and so, so and so. So and so. So therefore, my lords. Which one? Can I request? Can I request para 70 of BP Single's judgment, my lord, which loose copy was just given my BP Single, my lord, para 70, page 366, para 70, my lord. We have, however, already rejected the contention of the governor should be in sync with the ideology of the union government. Therefore, the governor cannot be removed on the ground that is not in sync or refuses to act as an agent of the party in power at the center. The governors, ministers, and attorney generals of all hold during the pleasure of the president. There is a strict difference between the office of the governor and the office of the minister and the attorney general. The governor is the constitutional head of the state. He is not an employee or an agent of the union government, nor part of any political term. On the other hand, the minister is handpicked member of the prime minister's team. The relationship between the prime minister and minister is purely political. Though attorney general holds a public office, there is an element of lawyer-client relationship between the union government and the attorney general. Loss of confidence will be therefore be a very relevant criteria for withdrawal of pleasure in case of minister or attorney, but not relevant ground on the case of governor. So that is how they distinguish between a governor, my lords, of the union government holding doctrine of pleasure and and here is a case, my lords, appointed by a previous government. That's it. It says that during the pleasure of the government. So therefore, irrespective of what, they are entitled to it, and the appointment of also is limited, my lords.
So we conclude. You want to give a synopsis?
Sure, I'll give a synopsis. Furnish a synopsis. But this BP Singhal case, my lord, I would like to refer to some of the passages because it deals with the concept of doctrine of pleasure in general. Though the distinction is made, which my learned friend is in reference to the Attorney General post and ministers. The court holds there is nothing called as an untrammeled right of this doctrine of pleasure. The court no doubt says that they need not give reason, but you cannot remove a person merely because he is not sync with your policy or he belongs to opposite political party. Exactly what they are now doing is, maybe, my lord, they can pass an order and they may reconsider and give a different order in respect of each case. But to say that whoever is appointed by the previous government will be removed, my lord, that is not an acceptable reasoning at all. And where is the question of previous government and the present government, my lord? This kind of orders, it cannot be sustained at all. Limited judicial review is available, is what this is. Not that in every case it can be examined, but a limited judicial review is available. And the Supreme Court specifically says in paragraph 24, the doctrine of pleasure in its absolute unrestricted application does not exist in India. So the court also says a governor cannot be removed merely because he is not sync with your policies. Now, maybe, my lord, I do not have an undefeasible right to continue. But the question is whether on what basis the government can act. Merely because the new government comes, I will remove all persons who are appointed in the earlier, whether that is sustainable is the issue. May not, even if I succeed, my lord, ultimately they may remove me. That's a different issue. But whether the action of the state, whether that could be accepted or not.
So heard learned senior counsel, Mr. So-and-so, assisted by learned advocate, Mr. So-and-so, for the appellant, learned advocate general, Mr. Sashikaran Sethi, assisted by learned
Shweta.
additional government, Sweta
Krishnappa.
Krishnappa from one state. Who else appears? Anybody is appearing? Any other parties there?
No, man, in this, there no other.
Comma at length. Learned counsels for the respective parties submitted that they argued the appeal finally, and further that they further stated that readings are complete and no further are required to be added or supplemented. Who appeared for number 4, Central Relief Committee?
I appear.
For all the respondents. All. Resort for judgment.
There is an interim order, my lord, may be continued till your lordships passes the order.
It is there interim.
There is an interim.
There is an interim order.
It will naturally continue. It is limited.
It is, has to be continued.
No, man, we will not take, let it continue.
Till next date. Interimly already operating in the appeal shall continue to operate. Follow the pronouncement of the judge. Till the pronouncement of judgment and to follow the till the pronouncement of judgment.
Rashmi, can you give us synopsis by Monday? Can we file?
You can by Monday, Tuesday.
By Monday. And Friday.
Yeah.
No, just because it's 4:26, end of the day. No, I've actually, just give me one.
No, you can't mention out of turn. You can't
mention out of turn. There is some requirement.
Yes, they're not getting up. When getting up, you can mention.
The door will open. Don't worry, not
I'm not here to run. There's all legal work. I'm here as much as for law and justice as you are here.
Somebody.
May I make a request, my lord? Oh, I thought my lords are raising. That's why I stood up.
Who said?
Oh, I thought so.
If you all want us to rise, we are ready to rise.
No, my lord. We are all waiting for our cases.
Yes, next.
Cell number 106.
No mention in between. Yes.
The K. Krishna.
Respond. It's 2:30, right? Okay, I have to.
And the next is there.
My lord, this is a case, my lord, where the acquisition is sought to be quashed by the learned single judge, my lord. The acquisition was for the purpose of KIDB, my lord.
This can wait for some time.
My lord, the only reason is just and we have given the land to Metro, my lord. Now, portion of the land, my lord. Now the Metro work has totally stalled, my
So far
lord.
as the metro land is concerned, we have made a statement. If compensation is given to us as is given to others, we will give
Yeah,
up
then
the
that
land
is-
itself.
we have no objection insofar as that is
We have
concerned.
made a statement before the single judge.
Then let
If
it
they-
continue, let
If
it
they
continue.
make if they give the
They're giving
deposit
that.
compensation as is given to adjacent holders.
Let it be recorded, my lord. We'll go ahead with that.
What is the statement you are making?
Lord, no, so far before the learned single judge, so though I challenge the acquisition for the larger extent, one portion, my lord, is being used by the one Metro wants to use it. So far as the land which the Metro requires, notwithstanding the quashing of this acquisition, if they give me compensation as is given to adjacent holders, Lord, I will give up that portion.
Then whole appeal goes.
So far as Metro is concerned.
Ah.
Yes. In fact, kindly see, Lord, that
this is only for
observation made before the single judge.
30.
Kindly see page
No,
36.
this challenge is in general or qua Metro only?
Only for Metro.
Then for Metro, he makes state.
Lord, kindly see page 36, Lord. Only one para.
Then there is no urgency. Then
But they have to give us compensation. They are not giving me
Learned
compensation.
Senior Counsel mentions
Kindly see page 36, my lord, of the first.
Para 15.
891. In fact, Mr. Arnold is absolutely right. They've already made a statement. Now, my lord, now kindly see paragraph 17 also, my lord. Learned Counsel for BMRCL submits that the compensation amount in respect to the lands needed has been deposited with the KIDB. If the KIDB is prepared to pay the said package amount, the statement of the petitioner that they would hand over possession which is earmarked is placed on record. So therefore, my only request is this. If that amount is already deposited.
No, they
the
have
amount is released.
they have
Let them hand over
deposited-
possession so
they have
that- so that we can restart our work.
No, they
All
have-
along before the learned single judge, my lords, only BMRC.
who will release the amount.
Now, my lord, the amount is with the KIDB. KIDB has to release it. to the
We'll
petitioner.
release it, my
That's
lord.
all, my lord. That statement will be recorded and then we may be permitted to continue work. The only urgency is this, my lord. This is a very
Port of-
important infrastructure project.
KIDB,
And
Lord,
the city to
To
the
the airport.
deposited lower amount.
About 11 guntas of land, because of which we're not able to complete the work, and there's a deadline. We are also bound to complete the work by 2026 or end of
Court of
2025.
My lord, this is the interim order which was pending before the learned single judge. After hearing the parties, my lord,
No, acquisition by Metro, that is the problem.
well, the beneficiary is the Metro. Your lordship may kindly see, this is the interim order which was there before the learned single judge, my lords. In view of the matters being referred to full bench, all the parties are directed to maintain status quo in all respect in relation to the lands as on today, except that portion of subject lands which has been acquired for the benefit of the respondent BMRCL. It is further clarified that order of status quo will not come in the way of BMRCL proceeding further in respect of portion of the subject lands. It is further directed without prejudice also. So therefore, this order may continue only insofar as BMRCL.
No, so far as BMRCL is concerned, my lord, there is no acquisition made by the BMRCL. We do not know on what date
Where is the question of court making any clarification? It is.
Let them, Lord, we are
Single
ready to sit
judgment.
with them. We are ready to sit with them. Let them.
So
tell us
let the
what-
same interim order continue before your lordships also, my lord,
That interim
pending
order-
consideration of the writ appeal.
That interim order, my Lord, cannot be.
Interim
continued.
arrangement, my lord, and compensation also will be paid to them as being given for other metro projects.
So far as, my Lord, my larger extent is concerned, they have locked this particular land in 2002. No award is passed. I am virtually on streets now. No compensation. Award is not passed. 2002 is the date of
The
acquisition.
judgment and order which is thought to be impugned. The judgment and order of law on a single judge which is sought to be impugned in this writ appeal. Dated 8th April 2024. Quashes the acquisition of lands of the petitioners. The general manager, land acquisition and estate BMRC land section is the appellant, who has challenged the judgment and order. In course of the submissions made by respective learned councils, today it was inter-alia pointed out that out of the lands acquired, some certain lands were
About
acquired for the purpose of
12,000 square feet.
metro rail project
square
for the
meters.
benefit of.
Right,
What
12,000.
is BMRC?
BM, Bangalore.
Metro Rail Corporation Limited.
Bangalore Metro Rail Corporation Limited. Full stop. It was stated that in respect of such portion of land which was acquired for the metro project for BMRLC, before learn a single judge. In the proceedings of learn a single judge, order came to be passed on 3/11/22. In IA number 1 of 22. Full stop. The aforesaid order dated 3/11/22 passed in IA, reads as under. Quote this order.
Let that order pertains to the entire portion. It should be confined only to the land required for BMRC.
No, no.
It's only portion to BMRC area. We are only for.
Said order, the said order.
No, that is a status quo order for the remaining land.
Said order,
Let that continue.
That is not, I am opposing because
kindly listen. The said order, inter alia.
only for BMRC land, I am.
Kindly listen.
Sorry.
The said order inter alia clarifies that the status quo will not come in the way of BMRLC proceeding further in respect of its portion of subject lands. Full stop.
The remaining.
When the petition was disposed of, law on a single judge, when the writ petition number 4800, while disposing one of the writ petition number 48002 of 18 dealt with in the impugned common judgment and order from a learned single judge, observed thus in paragraph 15 to 16, recording statement of learned advocate for petition number 2, that portion of lands belonging to petitioner petition 1 and 2 is already handed over to BMRLC.
Ready to hand over.
Has been earmarked for the use of BMRLC, and that the petitioners are ready to hand over this land, provided the package compensation offered by BMRC is offered to them. Full stop. You quote the paragraph 15 to 16, which is as under. After quoting, in view of above observations made by learned single judge, it was stated by all the learned advocates who were in broad agreement that the possession of the land acquired for the metro project is already with the,
Not already, my lord. We are ready to hand over, is provided they pay the compensation.
could be handed over to the authorities, provided the
Compensation.
compensation is paid. Full stop. In this regard, learned advocate general stated that the KIDBA will
Release the amount deposited by the
release the amount deposited by BMRLC.
Not accepted.
And the exercise shall be, and the exercise of releasing the compensation amount to the KIABD shall be completed within 10 days from today. The rest will follow.
Now, BMRCL will have to give it to us. my lord.
Full stop. Upon the amount is released as above, form will be open for the petitioner to seek the disbursement of this said amount of compensation by making a formal application along with the copy of this order. So everything is in.
Let us clarify one.
Without-
There might be some subject to correction. The learned civil records that issue, counsel for DMRC submits that the amount is already being deposited to DI.
That is not correct.
Of course, it is correct, but it's already been deposited to
If it
DI.
deposited, we release it. If it not deposited,
Well,
Will-
it's not my statement, also all instructions submitting that.
It is
amount.
deposited. they think it's deposited, you have to be recorded.
We'll say it is deposited, already deposited with the KIADB. If not deposited, shall be deposited within 10 days and then
Blood, this,
Work may be continued, or will be permitted to continue once we. because
it is the question of continuing.
Just to cover,
Rest,
blood, this is without,
the rest of the aspects in the appeal shall be examined at the time of hearing of the. Stand
blood,
out
this
to,
is,
stand out to 3rd December.
blood, without, this is without prejudice to our right to claim enhancement as per law, because we do not know
It
what.
goes
amount-
without saying that the release and receipt of the amount of release of the compensation by the authorities and the receipt thereof by the petitioner shall be without prejudice rights of the
Claim
petitioner
enhancement as per law.
claimants to claim the enhanced compensation in accordance with law.
Number 107. Rajesh Shetty. Loknath Patil person.
Yes,
For the appellant in this matter.
you are. You. Oh,
This is a matter,
Complainant in.
Contempt petition.
this is a matter where the respondent number 2 was employed in LIC. 2011, he was arrested by the police. Thereafter, he was placed under suspension. The suspension order is at page 208, your lord. On 10/10/2011, he was placed under suspension. Thereafter, charges were framed against him. That is at page 209, your lord. The 5 charges were framed. My lords, he sent his reply to the charges at page 216, your lord. Annexure R3. Thereafter, the suspension order was revoked.
What is the significance of date 24/11/2012? What is that date? 24/11/12. What is that date?
24/11.
2012,
On that day, he was removed from service.
removed from service.
Yes,
With retrospective effect of 9 months.
he was removed from service.
So why did he?
There is violation.
Mistake. Why did he know inquiry is directed?
No, his contention is that he was unable to attend the inquiry because his subsistence allowance was not paid.
Not paid.
It was paid. He actually, what he has done, when the inquiry was going on, he has specifically written a letter saying that I am boycotting this inquiry. The lordship may kindly turn to page 221. He was called for inquiry for 4 months. He was called. He sends a reply at page 221. Annexure R6, your lordship. He says, I boycott the inquiry, which is unlawful breach of trust and also follow by the criminal breach of trust.
You yourself stopped the payment of subsidies.
No, your lordship may kindly see, kindly turn to page 232. That issue regarding subsistence allowance was already settled. He himself has written a letter to me saying that I withdraw all issues raised by me with regard to payment of subsistence allowance in the interest of my family.
That is
Please-
a statutory obligation. His
Yes.
withdrawal, his concession will not work.
That amount was paid. Then the inquiry proceedings took place.
Finding of learned single judge is that it is not paid. You discontinued it. And the finding of learned single judge is also that because just he wrote a letter that he is boycotting, you treated him to be not participative in the inquiry.
No, your honor, your lordship may kindly see.
We are for the time being saying in your favor. If you start interrupting, we'll start saying against you many things on merits.
Annexure R11, your lordship may kindly see. That was dated 9/5/2012. On that day, the entire issue regarding subsistence allowance was settled. Thereafter, the inquiry proceedings were conducted. So since the issue regarding subsistence allowance was settled.
We'll take up for hearing. It will take some time.
No, my lordship, it's a matter of one observation. This honorable court may come to the conclusion that whatever is represented or submitted by the appellant is utter false. Kindly see D6 in the same booklet of my synopsis in page number 40. The entire salary slip shows nil pay. Nothing is paid for the first 9 months. My lordship, I was suspended on a false and fabricated case and followed by an illegal demand of 10 lakhs by the police. I protested. And nothing is paid. It's all nil payment from October 2011, from the date of suspension for nearly 9 months. And when I asked for it, they did not reply. I wrote 6 postcards, 2 emails, and two letters through courier. And I issued a legal notice.
My lords, he was removed from service on 24/11/2012. Thereafter, almost for 10 years,
Yes. It's one submission. When I issued the legal notice on 24th of April 2012, they extorted my wife, summoning to the office, obtained a blank check of 50,414, and they deposited that amount got from my wife to my account. Is it the subsistence allowance? Where is it in the statutory provisions of law? It is not the subsistence allowance that they have paid to me. It is the cooperative society recovery made from my wife's salary. My lordship, when I issued the legal notice, they have extorted my wife, for which I have filed a criminal case against all the 7 officers who are responsible for the extortion of the spouse. And with the letter dated 9th of May 2012 is that they extorted me after that, after obtaining a check and paid to my account, which is not the subsistence allowance, which is the money got from my wife's account. Kindly peruse page number 53 of my wife's salary bank account, my lordship. Page number 52.
Para 17 of the order. These submissions are considered in the backdrop of the fact that the petitioner has not participated in the departmental proceedings, citing difficulty because of non-payment of subsistence allowance, and he has commenced the proceedings in OS number 1028 of 2012 for injunction against.
Read paragraph 15. It is your concession.
When queried, the learned counsel for the respondent submits.
Fully read. When queried.
Yes, your lordship, read it. When
Don't
queried, the learned counsel for the respondent submits that if dismissal order is interfered in the circumstance of the case, the petitioner will be entitled to reinstatement, but because of a strong case is made out for de novo inquiry on the petitioner's association with Messrs. Metro Marketing Network Company and unauthorized absence, the petitioner's entitlement from the date of his unauthorized absence to the date of his reinstatement will have to be made subject to further inquiry that will have to be held.
That is what is made by Learned Single.
Now, Your Honor may kindly see in this,
Upon your own submission.
in this matter, departmental inquiry, and there is an order for reinstatement. 2012, he has been dismissed. When there is a order for inquiry, he cannot be ordered for reinstatement. Is the discretion of
Your
the
own concession, Mr.
No, not for reinstatement.
Yes, it is. Where is it?
I have sub,
If the dismissal order is interfered with,
I have
in the
submitted.
circumstances of the case of the petitioner will be entitled to reinstatement, but because of a strong case is made out for de novo inquiry on petitioner's association with Mrs. So-and-so, the petitioner's entitlement from the date of his unauthorized absence till the date of reinstatement will have to be made subject to further inquiry that will be held. That is your submission. It is so done. So directed by Learned Single.
Regarding inquiry, there is no issue. Reinstatement part, your lordship may kindly say, there is a settled judgment of the Honorable Supreme Court. I have produced one judgment. Para 16, your honor may kindly see. I have submitted on the last day. It is settled law proposition that once the court sets aside an order of punishment on the ground that inquiry was not properly conducted, the court cannot reinstate the employee. It must remit the case concerned to the disciplinary authority for it to conduct the inquiry from the point that it stood vitiated and conclude the same. Now-
Submission. One humble submission. I am suspended on 10th of October 2011. I wrote postcard at the end of the month. No reply. Within 90 days, the office is supposed to review the suspension order. It is not done. There is an order from the Honorable High Court of Delhi, passed by Justice V. Kameshwar Rao Jain. If I read it in page number 61, last 4 lines, my lordship. Alternative, revoke the same after a completion of 90 days from the date of suspension and treat the suspension period as a petitioner being on duty with full pay and allowances. They did not pay the subsistence allowance. I wrote postcards. They did not review. On 12th of October itself, immediately after 2 days of my release from the judicial custody on bail, I have written a letter on 12th of October with the information that I am released on bail and I may be taken for duty. And they did not respond to the letter. They did not respond to the postcards. They did not respond to the emails. Nothing is done within the period of 90 days, which is the statutory rule as per the central CCC on suspension. An order of suspension in page number 63, my lordships, an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before the expiry of 90 days from the effective date of suspension. It is not done. I repeatedly requested. And when I gave the legal notice for violating the statutory provisions of law, conduct of the inquiry without payment of the subsistence allowance, they extorted my wife illegally, unlawfully, fraudulently, and it's a criminal breach of trust. And they have threatened my 2 kids. They have threatened my 2 kids along with my wife and obtained the blank check. And they have obtained 2 blank letters. It's all unlawful. Criminal breach of trust by the biggest organization, LIC of India, which proclaims and says, Yogakshemam Vahamyaham. Where is the statutory provisions of law? Is it the law of the land to extort the wife for the mistake of the husband? My lordship, I'm sorry. All these things are brought to the notice of the court at the first instance in OS 1028 with the case of bus conductor getting back the duty after suspension. And I made my appeal before the honorable courts at all levels from pillar to post, and it was not considered. And when I entered RSA, honorable justice in the High Court made a liberty to approach the honorable court with a writ petition. All employees on suspension, if not paid the subsistence allowance, they commit suicide. What about the state of the family, the wife and children? It is all suppressed. False affidavits are filed by the appellants. In all the courts, all false affidavits, they say subsistence allowance is paid. They have extorted my wife and obtained a blank check, and that amount is paid to my account.
After his removal from service, he has challenged that order before the civil court. For almost 10 years, the matter was pending there. After 10 years, he approaches the learned single judge instead of approaching the appellate authority.
Right down, heard learned advocate. Mr. So-and-so for the appellant. And learned part in person. Learned respondent part in person, original petitioner. The challenge in this, sit down, both of you. The challenge in this letters patent, this challenge in this writ appeal filed under section 4 of the Karnataka High Court Act 1964. 64 is directed against judgment and order of law and a single judge. In the petition number 15264 of 2022. Full stop. The petition paragraph came to be allowed in part. Petition of the party in person, respondent herein came to be allowed in part. Order of dismissal dated 24/11/22, 24/11/2012, passed against the petitioner was, not was, came to be quashed. The respondents, thus the appellant employer, was permitted to initiate de novo inquiry against the petitioner. Petitioners Association. Petitioners Association.
The association with some company.
Petitioner in respect of alleged unauthorized absence.
For clarification, my lordship.
While
I was a private school teacher. And many.
once the order starts, this court will not tolerate any interruption. What did you write? For alleged unauthorized absence. Whilst directing the de novo inquiry, while giving liberty for de novo inquiry, it was further directed by learned single judge to reinstate the petitioner forthwith to the post which he held. It was observed and clarified by, it was observed and stated by learned single judge, it was observed and directed by learned single judge that the claim of the petitioner for the benefit from the period from 24/11/12 till the date of reinstatement is left open to be decided in accordance with law, subject to the outcome of the press inquiry which may be conducted. Noticing the basic facts in the background, the petitioner was in employment as programmer grade 2 under Life Insurance Corporation of India, the appellant herein. It appears that pursuant to an FIR being crime number 121 of 2011 registered against the petitioner for the offences under the provisions of IPC and under the provisions of the Price Sheet Money Circulation Banning Act 1978, the petitioner came to be suspended on the ground that he was taken in police custody. However, the suspension was revoked on 22/2/2012. Full stop. It appears paragraph that subsequently the employer imposed penalty of dismissal from service under regulation 39(1) small f 1 regular f small of the Life Insurance Corporation of India into bracket staff regulations bracket over 1960. It appears that in the inquiry proceedings which culminated into the order of penalty of dismissal dated 24/11/12, the petitioner had no effective participation. Paragraph. It further appears and observed by learned single judge that the employer, that's the fourth respondent, referred to the email of the petitioner dated 7/8/12, in which the petitioner had threatened to boycott the inquiry. Full stop. On the basis of such email, it was concluded that the petitioner was not willing to participate in the inquiry. It further appears that before the inquiry proceedings, certain proceedings of civil suits were instituted by the petitioner for declaration that the inquiry proceedings were illegal and invalid on the ground of non-payment of subsistence allowance. The suit was dismissed on the ground of maintainability. Supposed to be as that it may. since the petitioner challenged the order of dismissal dated 12/14 dated 24/11/12 by filing the writ petition. Also called in question the non-payment of also called in question the suspension and further complained about non-payment of subsistence allowance. Learned single judge recorded in paragraph 6 that the fourth respondent employer stopped the subsistence allowance on the ground that the petitioner had not reported on duty from 27 to 12, though the suspension was revoked. Full stop. The total controversy, as could be seen from the facts, booked. Two aspects. Firstly, the challenge to the dismissal order dated 24/11/20, passed pursuant to inquiry. Full stop. The attendant dispute was whether the petitioner had effective participation in the inquiry proceedings or not. Second aspect was about non-payment of subsistence allowance during and after the period of suspension and during the pendency of inquiry. In this regard also, there are rival contentions. Full stop. It could be noticed from the order paragraph that it was the submission of the petitioner himself that the petition could be disposed of by causing the dismissal order with liberty to the respondents to hold de novo inquiry on these charges, which were 2 in number, with appropriate direction. Full stop. This was recorded by learned single judge in paragraph. This was recorded by learned single judge in paragraph 16 of the order. Then quote paragraph 16. Full stop. As against this, the stand of the respondents in the above regard was reflected in the observations of learned single judge found in paragraph 15. So quote paragraph 15. Full stop. In light of the above conspectus of the controversy and the concessionary submissions made by both the sides, learned single judge dispose of the appeal by permitting the employer to start de novo inquiry in respect to the charges and further directed to reinstate the petitioner without any monetary or consequential benefits which were made to be subject to the outcome of the press inquiry which may be initiated. Two defects would be immediately noticed. Why you are standing? Your matter is there. Takes it. We don't like anybody standing. Please.
I just don't speak after the order.
We'll never complete the order. Yes. What did you read? Two defects could be immediately noticed in the operative part of the judgment and order of learned single judge. Firstly, while permitting the respondent employer to conduct a de novo inquiry against the petitioner, no time limit is fixed, which ought to have been done by learned single judge. Secondly, as per the reinstatement part is concerned, in view of the decision of the Supreme Court in Chairman, Life Insurance Corporation of India versus S. Masi Lamani, 2013, 6 SCC 530, the learned single judge was not right in directing reinstatement of the petitioner while permitting the fresh inquiry. Full stop. In the aforesaid decision in S. Masi Lamani Supra, in S. Masi Lamani Supra, the Supreme Court observed thus, then quote this paragraph 16, brigade person. It is a settled legal position that once the court sets aside an order of punishment on the ground that the inquiry was not properly conducted, the court cannot reinstate the employee. It must remit the case concerned to the discipline inquiry for it to conduct the inquiry from the point that it stood vitiated and conclude the same. Inward comma or, and then into below that paragraph 16. Paragraph in view of the above position, comma, the appeal deserves to be allowed in part with following direction. One, the part of the direction of learned single judge insofar as the reinstatement petition is directed is set aside. Two, the employer shall not be obliged to reinstate the petitioner during the pendency of the de novo inquiry which may be conducted by the employer. Three, full stop. The inquiry which may be proposed by the respondent employer, appellant employer shall be completed within a period of 4 months from today. Full stop. Four, if the appellant employer decides not to conduct the inquiry for any reason, comma, the respondent petitioner shall be reinstated. If the inquiry is to be initiated, it shall be initiated within 10 days from today. If the employer is not inclined to conduct the fresh inquiry and wants to leave the issues as they stand, comma, the petitioner shall be reinstated within 15 days from today. The appeal is disposed of accordingly.
Contempt also. Connected contempt.
The aspects of substance allowance is kept open to be agitated in independent proceedings, which may be instituted by the petitioner. Right?
Contempt may be closed.
Contempt does not survive any of the above. Contempt application does not survive.
Contempt may be taken as a separate issue because.
Contempt separate issue, all a separate issue. When do we want?
Because there's a lot of extortion of my family.
All.
Myself,
Contempt.
and also,
Contempt will be listed on 16th December. So when contempt comes up for consideration, keep this judgment ready. Yes. You know. We are afraid that we will be able to take up your matter because you are standing every time and requesting every time, urging every time in a very nice English language. But unfortunately, we are not able to take up your matter. So would you like to go before any other bench?
number 81.
For time constraint, we are not able to take up your matter. And we are not fortunate enough to listen to your very nice and succinct arguments. So you can go before any other bench. So no time, the time is over. Any hearing beyond the time is without jurisdiction.
I've been standing to draw the attention of the Honorable Court. I understand now that
We permit you to.
Making a mention,
We-
was the Honorable Court calling the case.
We permit you to go before different bench so that your matter can be taken up.
No, tomorrow morning, if it is listed.
That is, you are sitting throughout since morning. So since this bench is not able to take up for 1, 2, 3 good reasons and time constraint, we can.
So I should just wait for the orders to be issued.
Right now, we will allow. Which matter is there? Despite insistence. Despite unrelenting insistence made by party in person, petitioner party in person. This court is not able to accede to the request of the party in person to take up the case out of turn. Full stop. For want of time, comma, since the petition could not be taken up by this court, comma, and in view of the repeated request made by party in person, comma. Let the, what is this appeal? Petition. Let the writ appeal may be listed before another bench. Before a bench, before another bench. For this purpose,
Has clearly recognized the breach of patent cooperation treaty. And this writ appeal was filed on
that you submit before the bench. For this purpose, comma, the registry is directed to place the writ appeal.
I want to be heard in front of you, Honorable Chief Justice.
But we have no time. And we have no patience. Both together,
Your Honor, I'm not asking much. I'm only asking for the interim relief to be granted.
without hearing, we can't pass.
Right on 1/7. I do not want to impose myself on the honorable courts. I'm only saying that because the honorable court has recognized the breach of patent cooperation treaty, the interim relief be granted to me and then the matter be adjourned for a December date for me to provide the status of the receipt of the consent letter and the filing of the original suit.
It can't be done without hearing.
And I filed the writ appeal on 1/7, and which is why it was for to seek, get the interim relief, which is what is my request, humble request to the honorable.
It can't be granted like that unless we are convinced after hearing you.
So, could it be relisted again for, if, could it be called so that the respondent, if they have any objections, they can, let me know? Because there is actually no argument.
Paula, who is appearing for responding?
Your Honor, like the honorable court has recognized there is no argument in the matter, for the
The
interim
rest,
relief.
rest matter.
And if it is called, if the respondent, it has been 3 months and they have not filed any objections, and that is true because the breach of PCT has been fully.
Maybe, but you want to argue, then you,
I'm saying that if they have had 3 months to file, if
So,
they had any objections.
what do you want? You want to argue?
I want the interim relief then, that's all.
Interim cannot be granted in that way. We can refuse in that way, but not grant. If you want refusal of interim, it can be by one line. If you want to press for interim, it can be only by hearing you. So we are sending you to different bench so that your matter can be taken up.
But if I want to be heard in this honorable here in CH-1.
Your choice then. Then wait in your, be in your queue.
Could be relisted in the next few days, maybe in the.
It can be
first half
registered.
of the day, first half of the day.
No, it can't be like that. It will go in seriatim only. Choose, now have your option decided. What do you want?
The respondent have been given about 6 months to issue the consent letter. And by the.
We are not hearing your matter.
If.
Today the time is over. What do you want? We want to go before the different bench, another bench. We are ready to pass the order.
No, I'll wait for this court to issue the orders. And so maybe in the next.
We are not going to issue the order. We don't know what we will do. Yes.
Then kindly, restrict to the other.
Pardon?
Restrict for the other bench. Tomorrow.
Part in person stated that therefore the matter may be listed before another bench. Full stop.
The earliest date.
In the above view, the registry is directed to place the appeal
Tomorrow, yeah.
on administrative side for appropriate orders.
May I
Serial
please,
number
your lordship,
73,
serial
my
number
lord.
25, your lordship.
73, my lords.
A date may be fixed, your lordship. Serial number
All date will be
25.
given.
Serial number 73, date may be fixed.
21, Lord. There's some urgency in 21. Actually, they have, the honorable court has set aside the transfer. The government has removed me from that place by using section 17 of the KIDB Act. Without authority of law. Tomorrow,
73.
because then it's single judges.
Four.
Please, no?
Serial number 73, my lord.
Please on Wednesday.
Pardon?
Wednesday. You take a
Wednesday may not be possible. Fourth is the earliest. What is the matter?
But by then it will become infectious, Lord, because they may
Oh.
affect. They have to pass subsequent orders, which they are, after this writ appeal, not, they may pass the orders and this may become.
What order?
Order of, the CEO would pass the orders. That's the issue. Chief Executive Officer, not government has passed orders and.
The transfer or dismissal?
Not transfer, not dismissal. They have removed me from that place. Though this honorable court has said that I have to be kept in that place. They have removed me from that place by using powers under section 70. Power to issue general directions under the act, the government, which they could not do. Then a single judge says that it has to be examined
Monday.
Monday.
If I
May I make one request?
Monday, give that matter for reading.
73.
May I make one request, Lord?
Yes.
Lord, Tuesday also I made a request. It is listed today.
Which
I am
one?
asking for an interim order. Monday, your lordship may take it up. Serial number 56, my lord.
Will have to be heard for interim order.
Yes, yes. I don't, may I make one minute, sir? Monday, can it be at 2:30 so that your lordship will hear me and the government advocate? And if I am entitled to, your lordship will grant me, otherwise no. Monday, 2:30, my lord.
2:30.
Your lordship. 8:30, yes.
That matter also at 2:30.
Serial
So
number
that
92.
it can be separated.
Your lordship, serial number.
92, my lord. Like Tuesday, or I mean.
Not possible.
Your lordship.
Urgency, PIL, my lord.
PIL, no.
Urgency is there. my lord.
73, my lord.
Your lordship.
Please, your lordship, serial number 25, it's an appeal against the order from commercial court. Your lordship, see, there's an urgency to the matter to be stayed. There's a possibility that they might go for execution. So kindly, any date may be granted, your lordship, I'm ready for argument. I'll advance my argument, your lordship. If a date may be affixed. Serial number 25, your lordship.
Serial number 73, my lord.
All date will be given.
Your lordship, your lordship,
51, my lord.
your lordship,
It will be given.
your lordship, serial number 20, my lord. Lordship, serial number
79.
Lordship, serial number 20, your lordship, is the education matter. Children's, grandparent, sponsor quota, your lordship, some admission is not taken by the respondent, your lordship, some urgency is there, your lordship, kindly. 1 to 5th standard student, your lordship,
Fifth.
please, my lord.
Date may be given, your lordship, please.